Court of sir. 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 Madam. Madam. Court of sir, madam.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಅದೇ ಕೇಳ್ತಾ ಇಲ್ಲ ಅದ ಅವ್ರಿಗೇನೋ ಕೇಳಿದೆ ಯಾಕಂದ್ರೆ 230 ಲಿಸ್ಟ್ ಏನೋ ಇದೆ ಅದಕ್ಕೆ ಕೇಳೋಣ ನೋಡಿ ಏನು ಮತ್ತೆ 230 ಲಿಸ್ಟ್ ಬೇರೆ ಇದೆ
10:30 ನೋಡೋಣ
ನೋಡೋಣ.
ಒಂದ್ಸತಿ LCR ಫಸ್ಟ್ ಇಟ್ಬಿಡಿ Sir, am I audible?
Yes, madam.
Thank you.
ಇದು ಮೇಡಮ್ 2:30ಗೆ ಲಿಸ್ಟ್ ಬಾಳತ್ತಾಗುತ್ತದ 2:30 ಲಿಸ್ಟ್ ಬೇರೆ ಇದೆಯಲ್ಲ
ಐಡಿಯಾ ಇಲ್ಲ ಸರ್ 2:15 ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ಸರ್ 2:15 ಕರಿತೀವಿ
ಒಂದೇ ಬರ್ತದ ಒಂದೇ ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ
ಒಂದೇ ಸರ್ ಇಲ್ಲ 2:30 ಅಂತ ಒಂದೇ ಇರೋದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಓಕೆ ಬರ್ತದೆ ಅದು ಕೇಳಿದೆ
ಮೇಡಮ್ ಅಡ್ಜರ್ಮೆಂಟ್ ಮೂವ್ ಮಾಡಂಗಿಲ್ವಾ ಮೇಡಮ್
ಹೇಳಿ ಸರ್
ಅಡ್ಜರ್ಮೆಂಟ್ ಮೂವ್ ಮಾಡಂಗಿಲ್ವಾ
10:30ಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಇಲ್ಲ ಸರ್
No adjournment.
My lord, I appear for the respondent number 1, my lord. I filed these 2 applications. One is for setting aside the judgment and decree passed by the trial court, my lord, in respect of the very same property. And also one for the implement, my lord. My lord, what happened in this case, my lord, is appeal was dismissed for non-prosecution and it was stayed in the status of 5 years. My lord, it was restored on 4/12/2012. In the meantime, my lord, FDP proceedings were completed before the trial court. And this honorable court has made an order on 4/12/2012. My lord, any decree which is going to be passed by this judgment, my lord, is subject to the outcome of the appeal. So therefore, my lord, an appeal in the interregnum period, my lord, the first appellant, here in second appellant, my lord, sold the property in favor of a third person by virtue of a compromise decree. Therefore, I have sought for setting aside the decree, and also I have filed an application for impediment as him as a respondent, because my affect my interest, my lord, and also it is contrary to the judgment, my lord, passed by orders passed by this honorable court, my lord. Therefore, I request your lordship to issue notice to the impleading person. My interest has been jeopardized.
Correct. This appeal is arising out of judgment and decree
Of a decree passed in OS number
25 of 1993.
Yes, my lord.
You are seeking
Allah, judgment
of the
which is
judgment
now
passed in some other
subsequently.
suit.
Allah, my lord, what happened? A suit came to be filed by the impleading applicant, and it was compromised by the second appellant herein before the trial court. Without my knowledge and without bringing even to the notice of this the trial court, my lord, about the pendency of the appeal. A fraud has been played, my lord, before the court.
Where you can file an application under order 23 rule 3A
Before
which,
the trial court, my lord.
then why you filed the application here?
Allah, I have not filed the application there, my lord, because it came to my knowledge when the appeal is pending, my lord.
What is IA-1 of 2021?
IA-1 of 2021 is for setting aside the judgment and decree.
Of which OS number?
Which was one, just a minute, my lord.
OS 190 of 2016.
Yes, my lord.
Whether that is the subject matter of this appeal?
Yes, my lord, that is the subject matter of this appeal.
Subject matter of this appeal is OS number 25 of 1993.
Yes, my lord, the property which is now under a decree is also a subject matter of this appeal, my lord. It was allotted to my share in the FDP
And
proceedings.
file an application before the trial court.
With liberty, my lord, and without raising the limitation, because 2018, it came to me, my knowledge only recently, my lord, in the year 2021. I can file application there, my lord. It won't save the limitation. A fraud has been played on the court, my lord.
And file an application before the trial court.
Yes, my lord, with liberty to, my lord, that I can, without insisting the.
The response. After hearing for some time, the counsel for the respondent seeks leave of the court to withdraw the application. IA-1 of 2021, seeking liberty to file application before the trial court. This submission is placed on record. IA-1 of 2021 is dismissed as not placed with the aforesaid liberty.
With liberty, my lord, to approach the trial court and without insisting the limitation, my lord.
Section 14 is available to you.
Yes, my lord. Much obliged.
Pass on. Is carry out. Pass on. Carry out amendment, madam. What civil rules of practice? There is a circular. Pass on. When are you going to furnish them? Okay. The net counsel for the appellant submitted is submitted to not press IA-1 of 2019. Submission is placed on record. IA-1 of 2019 is dismissed as not pressed. Let the appeal be listed for final hearing next week.
Ms. Harish Kumar.
Notice to propose respondent on IA-2 of 2021. Take out the notice. The respondent has filed a memo reporting the death of respondent, sole respondent, who died on 30th May 2000, filed a memo dated 11 December 2020, reporting the death of respondent, who died on 30th May 2020, and also includes a copy of death certificate. In spite of knowledge, the appellant has not filed an application to bring the alarms of deceased respondent within time and by operation of law appeal is abated. Serve a copy today will dispose of this application. Also, please, just for serving a copy, do you require to be password? The password. The matters of the year 2010. Try to understand. Then at counsel for the appellant seeks time to comply with the office of the raised on IA 123 of 2021. Finally, 1 week time granted to comply with the office of the failing which appeal shall be listed for dismissal of IA. Old matters. Just for serving a copy, you require 1 year period.
Number 9. Yes, Maruti.
Also,
10. Yes, for them, Chandrasekhar.
Current counsel for the appellant filed a note stating that on inspection the parties to the appeal has settled the matter amicably and seek the leave of the court to withdraw the appeal. Memo is placed on record. Appeal is dismissed as withdrawn. Okay, is to them. Okay.
Number 11.
Yes, sir. The request of Karnataka counsel for the appellant with appeal to be listed on.
Serial number 12. Sidramanya.
ಡೋರ್ ಸೈಡ್ ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಮಾಡಿರೋ ಇಲ್ವಾ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಾಂದ್ರೆ ಹೇಳಿ ಮಾಡೋಣ ಮತ್ತೆ ಜೊತೆನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಕರೆಕ್ಟ್ ತಗೋಬೇಕಲ್ಲ ಅಡ್ರೆಸ್ Pass over ಮಾಡ್ತೀನಿ. Process. The application ಹಾಕಿ paper publication ಗೆ. Pass over ಮಾಡ್ತೀನಿ ಒಂದು application ಹಾಕಿ. ಕೊಡಿ ಕಾಪಿ. ಒಂದು ಕಾಪಿ ಕೊಡಿ. He has filed an application. Notice has to go to proposed response number 4. You filed a color. Why do you want a copy? Who will decide whether it's a proper or a proper party or necessary? ಅವ್ರು ಹೇಳ್ಬೇಕು, ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ಬೇಕು. ಏನಾಗಿದೆ? ನೋಡೋಣ, ಸ್ಟೆಪ್ಸ್ ಎಲ್ಲ ತಗೊಳ್ಳಿ. ಪಾಸ್
over. Serial number 13. Shri G. Janardana.
Take out a paper publication, pass or file an application. Pass or.
Serial number 14. Shri Venkat Narayan Sharma.
Yes, I'm query for appellant, my lord. Trace weeks time because it has been written that notice written saying that response number 2 be dead. Verify the particulars and I will file necessary application, my lord. Kindly give me weeks time, my lord.
Counsel for the appellant seeks time to take a steps. 1 week time granted to fix.
Please, much obliged.
Serial number 15. Hearing on IAS. Serial number 16.
I'm appearing for R3, my lord. I'll file my objection to the IA, my lord. I pray for 1 week's time, my lord.
Wants to file objection to I1.
Week's time may be granted. I'll file within that, my lord.
Correct application was filed in the year 2022. Then I counsel for response number 3 seeks time to file objection to IA1 of 2022. 1 week time granted to file objection to IA1 of 2022. Let the appeal be listed on.
Serial number 17.
Much obliged.
Properties are there and we are so many litigations for the right. We can all about the matter and we are representing these are one of the
Yeah. And this is why you are signing. Who is appellant? This side. Bernard Council for Respondent seeks time to file objections to IA 8 of 2026, IA 8 to 10 of 2020. 1 week time granted. Bernard Council for Respondent submitted they have received a copy of IA. Their submission is based on report. Bernard Council for Respondent.
Number 18. CH-20 party. Prashant Sarada.
Bernard Council for Government seeks time to file objections to IA 1 and 2 of 2021. 2 weeks time granted to file objections.
My Lord, I appear for the appellant in this case. My Lord, this is an appeal filed by defendant challenging the injunction order passed by the Honorable Trial Court in favor of the respondent, restraining him from not to put up any construction in the suit schedule property or to make any improvements over there. That's the permanent injunction granted. That has been assailed, and the settled principle that the boundaries would prevail over the measurement and the number of the property, my lord, would be aptly applicable to this facts and circumstances. And applying those principles, my lord, the appeal itself can be disposed of, in fact. In the meantime, my lord, I have made an application, my lord, seeking permission of this honorable court to put up a compound wall to the disputed portion, that is the appeal schedule property, which is measuring 8 feet by 92 feet, so as to avoid any nuisance. I have made an undertaking at paragraph 6 of the affidavit that in case the appeal goes against me, I would not be seeking any equity in that regard. I have enumerated the nature of nuisances that the appellant has been facing at paragraph 3. And to corroborate the same, I have produced even the photographs, my lord, the current status as to how it's lying. The central government made a preemptive purchase under Section 269 of the Income Tax Act. Then by option, the appellant herein purchased that. All the documents which holds as a testament to the vestitive facts, my lord. It gives a measurement of 110 feet by 92 feet. This suit schedule property is something imaginary one for the plaintiff who pursued that proposition before the trial court. And he has not placed any document to show that his brother, that is the vendor in the sale agreement, he retained that particular portion. He has not proved that proposition at all. Despite which the Honorable Court comes to a conclusion that that portion remains.
Where is your sale date?
Sale deed exhibit P14, my lord. Exhibit P14 at page 149 in the paper book, my lord.
What is the extent of area shown?
Your Lordship may kindly come to page 161, my lord. It is east to west 110 feet and north to south 92 feet.
So this extent you are entitled for it. But what about the others?
There is no other extent at all. Whatever is little extra, my lord, it would inure to the benefit of the title holder as a marginal land for its beneficial use. The boundaries which plays a very vital role in this case, my lord, is consistent and has been the same even in respect of the documents which relate to pre-independence period, my lord. Right since then, the boundaries have been the same. For the first time in the suit, he shows the suit schedule property as being the retained portion in the eastern part of the property purchased by the applicant, which is absolutely false. There is no such portion that has been retained by the plaintiff's brother. Even the agreement, my lord, that was executed in favor of some third party, turnkey constructions, the permission for which it was filed before the income tax department, even that agreement, my lord, comprehends the very same boundaries. It doesn't show any portion that has been retained by the vendor therein, either in the recitals or in the schedule there. The plaintiff, my lord, in law, my lord, has no justiciable right so as to say that he is entitled for that marginal land. Whether it is in the hind portion or in the front portion, nowhere is there any document to demonstrate that aspect. In fact, the plaintiff has also taken a share more than what was allotted to his brother, who has been the vendor through the central government to the appellant. He has got 98 feet by 110 feet, 118. All the properties, my lord, in fact, which are adjacent to one another in the Kanakpura main road, facing Kanakpura main road towards east, my lord, they are in the depth, having an extent little more than what is subscribed in all the testaments of vestitive facts. Merely because the plaintiff is class 2 legal heir of the deceased brother, my lord, the court comes to a conclusion that he will succeed to it, and hence he is entitled for the injunction. While the plaintiff's brother himself did not have any right as such, nothing would devolve upon the plaintiff. And even in the cross-examinations, my lord, of the plaintiff, it has been emphatically admitted in clear and unequivocal terms that it has been the appellant who has been in possession of the stretch, including the disputed portion, that is the suit schedule part. So the suit, in the manner as has been brought, merely for permanent injunction to restrain the appellant to put up any construction or to make any improvement. per se is not maintainable, having admitted that the appellant is in possession of. This portion of suit schedule property, my lord, which they alleged to have been retained by them, my lord, is supported by only a self-serving recital in a partition deed that was entered into between the brothers way back in 1981. Except for that, there are no other documents to support that contention.
What the dispute is only in regard to only to the extent of 8 feet.
Correct, my lord. Correct, my lord. And there are no documents to say that that is the piece of land which has been retained by the vendor in the eastern part of the property that has been sold to the appellant.
The appellant himself has produced the copy of a deed of partition, wherein
Yes.
property extent of measurement is shown in Schedule C.
Yes.
Will be 92 feet into 118 feet.
Correct, my lord.
Then
That
8
is-
feet.
Huh.
About the 8 feet.
My lord, 8 feet, even the central government could not secure any documents to hold as a testimony for that portion of land. So therefore, the central government has executed a sale deed for 110 feet. Even they don't have, even the respondent don't have any document to show that except a self-serving testimony in the partition deed.
Come to the boundary shown in the register sale deed,
Yes, madam.
page number 150, 163.
Yes, my lord, I am a teacher. Here, my lord, on the east by Kanakpura main road.
Northern side. On the northern side.
Northern side is Anand Rao's property, which is totally a different extent, my lord. We are not concerned with it. That is not the suit schedule property.
So property bearing number 57.
Yes, my lord.
So property is also survey property number 57 only.
Suit property is part of 57, my lord. Anand Rao's property is 57/1. That is pursuant to the bifurcation made after the partition deed. That lies to the north of the property bought by the appellant. The boundaries is admitted. Absolutely no dispute. The plaintiff, my lord, he is trying to play mischief due to the absence of any document to hold as a vestitive fact for the extent retained. It's a marginal and admittedly even by him in the pleadings in the plaint, which should inure to the benefit of the person who has bought that property, whether it is to the eastern part or to the western part. That is front or rear portion. Nothing is mentioned. It is eventually, my lord, the local revenue authority has to take some steps to collect any fees in that regard, if there is some excess land. Because earlier, even much before the, at the time of evaluation of this particular properties, my lord, It was originally 110 feet by 190 feet. It was sold by municipal commissioner way back in 1920s.
Come to cross-examination of PW1, page number 86.
Yes, ma'am. Yes. Yes, my lord. Yeah. I am looking at the boundaries that have been
Northern side.
described. Yes. Northern side remaining portion of same property means it was earlier measuring 190 by 110 feet, my lord. And it was after partition 92 by 110 and 98 by 110. It was divided in two portions. It is with reference to the portion got under the partition deed by the plaintiff.
Correct. You yourself has suggested that towards northern side remaining portion of the same
Yes,
property.
we are not encroaching that portion, and neither they are have any grievance in that regard, my lord. We admit that they are to our north, but the plaintiff says the front portion as between the property purchased by appellant and Kanakpura main road, there is 8 by 92 feet, which is an illusion. It is not supported by any document. The front portion of the property purchased by appellant, that is the one he disputes, not the one which is contiguous to this on the northern side. Kindly, my lord, in the same cross-examination, may I request your lordships to take page number 93, my lord, in the cross-examination. The last three lines of there is an admission, my lord. It says, it is true that the defendant is in possession of entire property, including suit schedule property. Page number 93. In fact, para 12 may kindly be read in entirety, my lord. They admit that they don't have any document to show that they are in possession of the suit schedule property.
If application under order 41 rule 27 is allowed, then I have to remand it the matter back to the transport for fresh evidence, for recording evidence on those proposed document.
I leave it to your lordship's wisdom, my lord. But
Once if I allow application for production of additional document, court has to remand the matter.
my lord, these additional documents are nothing but photos depicting the current situation whereby we are facing nuisance without there being a compound wall. So we may be permitted to put up subject. We will not claim equity. I have made a clear.
I'll dispose of the appeal itself. I'll dispose of the appeal.
My lord, the propositions that have been settled regarding the boundaries should prevail over the measurement, my lord. The citations of this honorable court, in fact, the division bench way back in 1990, my lord, and later by Justice Honorable Mohan Shantan Gowda in 2011, and also of the Supreme Court in 2006 in Shobha's case, my lord. All these three, I wish to bring it to the kind notice of this honorable court. Then, my lord, may I persuade this honorable court to.
What about IA 1 of 2022?
My lord, may I request your lordships to kindly allow this, my lord, subject to undertaking what I have made in para 6 of the affidavit, my lord.
Correct. If I allow this application, then I have to remand the matter back to the trial court to record evidence on those documents.
My lord, here the office has made a wrong nomenclature about the IA. The IA is not for production of documents. The IA is for seeking permission to put up construction subject to final result of this appeal. That is the prayer made in the IA, my lord.
You have filed a miscellaneous civil number 10051 of 2010 for production of documents.
My lord, the office must have got confused, but the prayer is very clear, my lord.
You have filed application on 7/7/2010.
Long back. Yes, yes.
If this application is allowed, then I have to remand the matter back to the trial court.
Yes, my lord. In the meantime, may we be permitted to put up the compound wall subject to outcome of the result after remand?
We'll dispose of the main appeal if you are ready for argument.
My lord, I have absolutely no objection with the proposition conceived by this honorable court. But my lord, so as to put up the compound wall, may we be permitted in the meantime, my lord. And we will not claim equity if after
We will
remand.
dispose of the main appeal. We will dispose of the main appeal itself. Why do you want disposal of IA 1 of 2022?
Yes, my lord. Regarding the propositions, my lord, of the boundaries prevailing over the measurement, my lord.
Settle law.
It is a settled law. Yes, my lord. Because even they don't dispute, the plaintiff don't dispute regarding that measurements, boundaries, in fact.
Admission of plaintiff is sufficient to dismiss the suit.
Yes, sir.
Instead of pointing out the admission of plaintiff.
My lord, at page 93, my lord, I have brought to the kind notice of the honorable court, paragraph 12.
On the application? What do you say on the application filed by you for production of additional document?
My lord, we will pursue it before the revenue authorities, those documents, after disposal of this.
Are you going to withdraw the application or you want a disposal on?
Can I have a days or 2 days accommodation, my lord? Kindly, my lord. I'll apply my mind and assist this honorable court, my lord. I'll do my best.
At the request of Lamet Council for the appellant, let the appeal be listed on Monday.
Much obliged.
My lord, I appear for the appellant in this matter. This plaintiff's appeal may not suit for declaration and injunction. Application filed for bringing LRs of the deceased respondent, sole respondent on record, my lord.
You got any objections? You are a LR of respondent or not? So there is no dispute about that. Carry out the amendment.
Please, my lord.
Will I pass out the matter?
My lord, your lordship may have it next week. I will, in the meantime, carry out the amendment and.
The last date of hearing, you took an adjournment on the same ground.
Amendment of the appeal.
Yes.
Yes.
Appeal number 21.
Malaj, I apply for the appeal in Malaj. So I filed applications to bring LRs of respondent number 1 Malaj. All the LRs have been served.
But any objection? Filed an application seeking IA number 2 of 2016 for setting aside abatement. And filed IA 1 of 2016 for condoning a delay of 285 days in filing LR application. And filed IA number 3 of 2016 for to bring the LRs of deceased respondent. Learned counsel appearing for proposed LRs submits no objection to allow the application. Accepting the reasons assigned in the application, I-2 of 2016 is allowed. Abatement is certified. I-1 of 2016 is allowed. Delay of 285 days is condoned in filing LR application. I-3 of 2016 is allowed. Appellant is permitted to bring the LRs of deceased respondent. Appellant to carry out amendment and to furnish amended cost title. What about IA-1 of 2017? File an application to bring the LRs of deceased appellant.
Appellant number 2 Malaj.
The net counsel for respondent submit that he has received a copy of IA-1 of 17. Most of the appellant has filed the LRs of. What is there, Mr. The LRs of appellant filed an application. IA-1 seeking permission to come on record as a LRs of deceased appellant. Learned counsel submits no objection to allow IA-1 of 2017. Accepting the reasons assigned in IA-1 of 2017. IA-1 of 2017 is allowed. Proposed LRs of appellant are permitted to come on record. Appellant to carry out amendment to furnish amendment.
Yes.
Will you argue the matter? Oh, sure. To argue the matter, take up the matter finally. That's the bit better. ನಮ್ಮ ಹತ್ರ ಐಡಿಯಾ ಇಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಇವೆಲ್ಲ ಓಲ್ಡ್ ಮ್ಯಾಟ್ರಸ್ ಇದೆ. At the request of Learned Counsel for the appellant, the copy be listed on.
In July, number 23, it is ready.
IA-1 allow ಮಾಡ್ಬಿಡೋಣ, ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡ್ಬಿಡೋಣ. Delay condone ಮಾಡಿ will admit the appeal and will post the matter forward. Appellant filed IA-1 of 2012 seeking for condonation of delay of 2 days in filing appeal. Learned Counsel for respondent submits no objection to allow IA-1 of 2012. Accepting the reasons assigned in IA-1 of 2012. I-1 of 2012 is allowed. Delay of 2 days is condoned in filing appeal. For the Learned Counsel for the party admit. List this appeal along with RFA number. Final hearing on.
Number 24.
Appearing for the appellant, my lord. IA for early hearing is filed by the respondent number 2, my lord. Matter can be heard finally. Suit is for partition.
Yes.
Between the brothers and sisters, my lord. any date may be fixed after 15th, my lord.
Well, it's appearing for respondent 1, 3, and 6, my lord. A date may be given after 3 to 4 weeks. My lord.
Filed IO application for early hearing.
By
It
respondent.
is respondent 2, my lord. I appear for respondent 1, 3, and 6.
Respond number 2 filed I1 of 2022 for early hearing, accepting the reasons assigned in I1 of 2022. I1 of 2022 is allowed. Let the appeal be listed for final hearing on 12 July. Right? The request of learned counsel for the appellant, let the appeal be listed. So issue submit said, yes, filed a wakalat for proposed respond number 10. Registry is directed to print the name of so and so for proposed respond number 10. This is it. Appellant filed IA1 of 2021 for recalling the order dated 26/7/2021. Learned counsel for respondent submits not fixing to allow IA1 of 2021, accepting the reasons assigned in IA1 of 2021. IA1 of 2021 is allowed. Order dated 26/7/2021 is recalled. Appeal is restored. Let the appeal be listed for final hearing. The order granted earlier is extended till next date of hearing. Yesterday, correct. Yesterday on your request matter is adjourned today. At your request matter was adjourned to today. You argue the matter, madam, today. Huh? At num paper book ಕೊಡ್ತೇವೆ ನೀವು ಪೇಪರ್ ಬುಕ್ ತಗೊಂಡು ಓದಿ ಪೇಪರ್ ಬುಕ್ ತಗೊಂಡು ಓದಿ matrix of the year 2006 ನಾನು ಪೇಪರ್ ನೋಡ್ಕೊಂಡು ಮಾಡ್ತೀನಿ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಹಾಕಿರಲ್ಲ ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಹಾಕಿರಲ್ಲ Baswachari doesn't have any legal head. Correct. Item number 1 was owned by Baswachari. Then now this plaintiff will get the property. Then Baswachari has got a legal representative. Their contention is that wife and children died. Yes, ma'am. Actually, defendant number 1 also doesn't get the property. Correct. Legal representatives of Baswachari was not a party to the proceedings. Defendant number 1 has filed a suit against defendant number 2 and 3. The defendant number 2 and 3, they are not the legal representatives. So this is a suit for partition and separate possession. First, plaintiff must establish that the suit properties are the joint and ancestral property. Hey, madam, mark the matter. Yeah, disposition. Then you have failed to establish that the suit property item number 1 is the joint family property. You have not produced any record to show that it was owned by father of the plaintiff, that is Narayan Chari. This appeal is fine, challenging the judgment and decree dated 4/3/2006, passed in OS number 47 of 1990 by the Civil Judge Senior Division and JMFC Chintaman. Parties are referred to as per their rank before the trial. The appellants are the plaintiffs and the respondents are the defendants. So the plaintiff filed a suit for partition and separate possession. So it is the case of the plaintiff that the plaintiffs and first defendants are the sons of Narayan Chari, and they form undivided in the joint family. So the plaintiff of what assistance faith and affection towards the first defendant, and all the suit properties are the ancestral properties. First defendant who is living, plaintiff and first defendants are living jointly and in joint possession of the suit property. Item number 1 of the suit property is a residential house, and item number 2 of the suit property is an agriculture land. The first defendant filed the suit invoice number 106 of 1995 against defendant number 2 and 3 The said suit came to be compromised and compromise decree was passed. It is contended that the consent of plaintiff was not obtained in OS number 106 of 1995. First of the first defendant is trying to alienate the plain schedule property to the defendant number 2 and 3. The plaintiff have arranged panchayat on 4/2/1996, but the first defendant, with the support of defendant number 2 and 3, has not honored the words of the panchayat, and defendant number 2 and 3 are trying to change the nature of item number 1 of the suit property. So the plaintiffs requested from effecting a partition. The defendant refused to effect a partition. Hence, cause of action arises for the plaintiffs to file a suit for partition. So the defendant number 1 filed a written statement. Filed a consenting written statement. Defendant number 2 and 3 filed a separate written statement. Contending that admitting that the plaintiff and first defendant are the sons of Narayan Chari, and also admitted that they form an undivided Hindu joint family. It is denied that the suit schedule item number 1 of the suit property is the joint family property, and the description of item number 1 is incorrect. And it is contended that the said property does not belong to joint family property of plaintiffs and first defendant. It is contended that item number 1 was originally belonged to Sri Baswachari, who got the same under a public auction conducted by the Tahsildar on 2/6/1960, is denied. The defendants it is contended that it is contended that the first defendant was the manager of the joint family of the plaintiffs and first defendant. There was some misunderstanding within their family, and finally, and family of defendant number 2 and 3. Taking undue advantage of the same by the political elements opposed to defendant number 2 and 3. First defendant filed a suit against the defendant number 2 and 3 in OS number 106 of 1995. The said suit was contested. A commissioner was appointed in the said suit who gave a report stating that item number 1 did not belong to their family And ultimately, the said suit was ended in a compromise. And rest other allegations made in the plaintiff is denied and paid to dismiss the suit of the plaintiff. So the trial court on the basis of the pleadings framed the following issues. The petition, the plaintiff number, the plaintiff in support of the plaintiff number 2 was examined as PW1 and plaintiff number 1 was examined as PW2 and examined one witness as PW3 and got marked documents exhibit P1 to P37. So the defendant number 3 was examined as BW1 and examined three witnesses as BW2 to BW4 and got marked documents exhibit P1 to D17. So the trial court, after recording the evidence and considering the material on record, held that the plaintiffs have failed to prove that suit item number 1 originally belonged to Baswachari and further held that the plaintiffs have further failed to prove that item number 1 of the suit scheduled property belongs to the joint family of the plaintiff and first defendant and held that the item number 1 is in possession of joint and further held that the plaintiff has failed to prove that suit item number 1 is in possession of joint family of the plaintiffs and first defendant and further held that the defendant number 2 and 3 have failed to prove that suit is hit by principles of reciprocity and further held that the suit is and further answered issue number 1, issue number 6 and 7 in affirmative and consequently decreed the suit of the plaintiff in part and declared that the plaintiffs are entitled for 1/4 share in item number 2 and 3 and dismissed the suit in respect of item number 1. So the petition, the plaintiffs being agreed with the judgment and decree passed with the trial court dismissing the suit in respect of item number 1 as filed this appeal or the learned counsel for the plaintiffs and learned counsel for respondent number 2 and 3. Learned counsel for the plaintiffs submit that the item number 1 is the joint family property. The trial court, without considering the material produced by the party, has wrongly held that the suit item number 1 is not the joint family property of the plaintiffs and first defendant and further she further submit that the first defendant having colluded with the second defendant, second and third defendant obtained a compromise decree in OS number 106 of 1995 and the said decree is not binding on the plaintiffs. The trial court, without considering the said aspect, has committed an error in dismissing the suit in respect of item number 1 of the suit schedule property. Hence, on this grounds, she prays to allow the appeal. Per controller and counsel for defendant number 2 and 3 support the interim judgment and decree passed by the trial court. Heard and perused the reports and considered the submission of the learned counsel for the party. The point that arises for consideration is whether the plaintiff proves that item number 1 of the suit schedule property belongs to the joint family of plaintiff and defendant. Next, whether the plaintiffs have made out a ground for interfering with the interim judgment and decree, henceforth order or decree. Heard and perused the reports. It is the case of the plaintiff that the suit item number 1 is the joint family property of plaintiffs and first defendant. in which the plaintiffs are running a blacksmith work, having a manure pit and using the same for other domestic purpose. And it is contended that originally the said property was owned by Baswachari, who got the same under public auction conducted by the Tahsildar on 2/6/1960. And the said auction purchaser and his wife and their children have died. Baswachari being the brother of Narayanachari, that is the father of plaintiffs and defendant number 1, who have succeeded after the death of Baswachari. And the item number 1 is the joint family property of plaintiff and first defendant. In order to substantiate the contention of the plaintiff, plaintiff number 1 was examined. Plaintiff number 2 was examined as given in the examination sheet. Except oral evidence, the plaintiff has not produced any record to show that the suit item number 1 was owned and possessed by the joint family of plaintiffs and first defendant. But the first defendant has filed a suit against defendant number 2 and 3 in OS number 106 of 1995. The compromise decree, the said suit came to be disposed of. And the defendant produced a copy of compromise petition filed in OS number 106 of 1995, which is marked as Exhibit D1. From the perusal of Exhibit D1, the defendant number 1 has clearly admitted in the compromise petition that the plaintiff that in OS number 106 of 1995, that is the defendant number 1 here, admitted that his joint family has no right, has no title, interest, claim, possession over the suit schedule property, and the property granted to his uncle Sri Baswachari is situated elsewhere and not the suit schedule property. And further, he has admitted that he was wrongly advised by the person, by the people inimical to the defendant number 2 to file this suit. And he has clearly admitted that defendant number 2 and 3 are the owners and in lawful possession of property measuring 40 into 50, such as for 40 to 50 feet. And the plaintiff has no objection for the defendant number 2 to the defendant number 1 has no objection for defendant number 2 to 2 and 3 to get the kata in respect of the property shown in the statement. In a suit for specific performance of contract, it is for the plaintiff to establish that the suit schedule property is of the joint family and ancestral property. The plaintiff has failed to establish that the suit item number 1 is the joint family property of the plaintiffs and defendant. The plaintiffs have not produced any report to show that the said property was standing in the name of ancestors of the plaintiffs. So the trial court, after considering the material on report, was justified in reporting the finding that the plaintiffs have failed to establish that item number 1 of the suit schedule property is not the joint family property of the plaintiffs and defendants number 1. Just in view of the above discussion, point number 1 is answered against the plaintiff. Point number 2. The trial court, after considering the material on report, was justified in recording the finding that the suit item number 1 is not the joint family property of the plaintiff and defendant and has rightly dismissed the suit in respect of item number 1 of the suit property. So I do not find any grounds to interfere with the impugned order. Accordingly, point number 2 is answered against the plaintiff. Point number 3. In view of the above discussion, I proceed to pass the following order. Appeal is dismissed.
Number 28, इसी प्रकार सफेद को आपकी
Okay. Bazia Kira. Yes, sir. ಯಾವಾಗ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂತೀರಾ ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ
number 29, GPN one more time.
Prepare for response number 1 and 2, my lord.
Yes. Yes, Mr. Sharma.
It's ready, my lord.
This item number 1 was the subject matter of partition partnership deed.
Yes, my lord. It is in
Partnership
as per
deed.
exhibit to P10, my lord. Exhibit P10, my lord.
Come to page number.
P10, page number 86, my lord.
How this property was transferred in favor of partnership firm?
After the death of Kanolkar, the mother, it has been transferred to the partnership firm. They have accepted that dissolution of partnership deed, exhibit P10. In that it was mentioned, my lord. All the properties whichever has been allotted to each.
You must establish that it was transferred in the name of partnership.
Yes, yes. Yes, yes.
Show me the document.
That is the dissolution of partnership deed, my lord. In that this property has been.
Show from the partnership deed, sir. It is your case that it is a partnership firm property.
Yes, yes.
As it was earlier, it was standing in the name of Sarojini Bai. After her death, property was transferred in the name of partnership firm.
Yes, yes. No, parties have treated that property as a partnership firm, and business was doing in that property only, my lord.
Where is the document?
Document means this exhibit P10
There is
only.
a partnership deed.
Partnership deed has not been produced, my lord. But they have treated this property as a partnership property. While looking to the entire evidence and documents, it shows that this property belongs to the firm. And kindly say exhibit P10, my lord, because they have accepted. This P10, all the parties have signed this exhibit P10.
What is this exhibit D2?
Which one, my lord?
Exhibit D2.
Exhibit D2 is the valuation report. That is a valuation report, my lord.
Where is the partnership deed?
Is there in exhibit D8, page 167. That is where the balance sheet and accounts balance sheet of sale. Nothing else.
The crux of the case is only if they establish that it is a partnership, then only.
They are not being able to.
Yes, Mr. Sharma.
Kindly after tomorrow, my lord, we will argue on that matter. We will see the.
Nothing,
No,
Sharma, you argue the matter.
Please, my lord.
No, you argue the matter.
Then kindly pass over, my lord. I will argue on that matter. Kindly pass over, my lord.
Also. That is the only trust of the issue.
That is the only issue, my lord.
Admission that we are doing.
Number 30. Wait for now.
Pardon?
For the sixth respondent. Appearing for the eighth respondent.
You are appearing?
Number 31.
No, sir. Matters of the year 2006. No adjournment. There is a suit for partition in separate possession. Yes. Where is the genealogy?
The stand of the appellant is of the scheduled properties as is the only legal right. And
Where is the genealogy? It's a genealogist. A suit for partition, that is important. Huh?
some accommodation. Sorry for
What is wrong in this? Assets being right there or other, she would not have maintained this is after the basic, the quality considered whether this is if the court comes to conclusion this no, the parent court comes to the conclusion that this is or it's an accessing issue number one is very affirmative. Issue number one, whether the rate is close to the properties are access to the property. First different. Now the board comes to the conclusion. Now the answer to the question is affirmative. I mean, we have contested one. For the future. Forty-two. Trial court has refused to grant relief. And the certain properties are not available to this let relinquishment deed also not be since cannot be done for widely declared cannot be party by applying section 6 cannot be declared as shares in the other shares. Hence the right is not ordered to existing property. Again, share this is item number 1, item number 2, 3, 5 and 8. Up to 6 item number 2 and item number 41 of the allow to again detail in respect of the remaining so far as cannot follow it negative during like that. You are also not following the question. So far as the shares of the credit is a relinquishment date. That is incurred of the third line. Third way. I don't know anything about that. So far as the good shares has been not taken into of the third line. Proceeding. See market. See now. So far as the two properties that are taken into the third line. It is a joint family property. You are not telling the findings recorded by the trial court on number 1. So release deed can be held to be valid only to the extent of share of a defendant number 1. Only to that extent we can hold. You're a second wife. Only property has to be divided in between adopted son and adopted kid. Or dependent number one is no more.
Dependent number one is no more. But the father and adopted son never maintained
That is before amendment.
after amendment also, whether the father and second father and adopted. Share surrendered to the father there is so for a relinquishment it is concerned, never have those two. Other doing is better to the daily problem. Other doing is like to the daily problem. Then the adoption.
So the crux of the case, the crux of the case in view of amendment to Windows Succession Act, totally entitled for equal share. That is the question involved here. Now, second wife is not entitled for any share. And moreover, as far as relinquishment deed is concerned, only to the extent of share of a father, that we can confirm, we can uphold that release deed only to that extent. What else is required for you? This is the crux of the case. What else you want to stay there, sir? In favor in favor of the court, the mind the request of learning council for the appellant follow. In favor
I appear for the appellant.
Yes, sir.
I appear for the appellant.
Yes, sir. Yes, sir.
My colleague was discharged after surgery. I praying time only till Monday. Sir. My colleague underwent a surgery and was discharged yesterday. 3-4 days bed rest because in this absence I feel a bit handicapped. That is why I'm praying adjournment only till Monday. I know it is a 2007 matter, so I'm not well justified in seeking an adjournment.
At the request of learning.
I understand. Not beyond Monday minutes.
It's Monday, sir. Monday.
My matter it is. Monday. Great.
Serial number 33, CH Kumar Jain.
Some problems with the bank with respect to the other banks. Yeah, only
the request of learning council for the parties later be listed after 19th.
21st July. Serial number 24. Shri R.V. Sadashivappa, Mohammed Safiullah Khan Karakal. Serial number 34. Shri R.V. Sadashivappa.
Just go through the reports more. Why you are seeking adjournment? Yes. Your appeal is maintainable. Under section 96. What is the impugned order? Good evening. Then an application under 1302A.
Lordship. Excuse me. Hello.
Yes, madam.
Hello.
Yes, madam.
Hello. Your Lordship, I appear for respondent number 2 in the matter.
Yes.
Hello. Hello.
Yes.
I kindly
Yes.
pray for a week's time. Senior is
Sorry, ma'am.
there is a death in the house. Senior is hello. Your Lordship, I
Already that property has been allotted to different number 2. Marginal land has been already allotted to different number 2. You filed an application for amendment of claim, challenging the allotment itself. At the request of Connect Council for the appellant court.
Number 35, CS Siddhappa, K. Prakash, Sharman ENP. S. Siddhappa, CH Mahesh. Number 36, CH Shastri.
I appear for the second respondent.
Who is this DW2? DW2 is a different number. Number 19. Cross-examination. At least in case of cross-examination, we can do at least test. Who was starting off right? Who was starting off further admitted that the 7 dependent proposition of the right. According to legislation, order of period is to what that this body was order. Is further admitted by legal to regard to see that his father had a job. This is typically admitted by legal to that his father should be which he as his mother law. These proves that he actually was the evidence of legal people does not show that the amount of it is specifically mentioned that under sensitive property to she has to this condition is considered. Here that the letter utilize for personal purpose and not personal purpose. We have to
authority that he does not whether his mother had it is admitted by legal to that his father had an intention to pursue property. Therefore, it is clear that this is admitted that property was purchased for the that purpose, and that was not.
The group 2 has admitted the contents of plain table match.
Not so. What is this intention now?
What is the
The question would be whether purchase made in the name of action or vested property number 7. But here may not be. The evidence is.
it was the condition in the sale?
That was not the condition in this AD. It was sold for some social benefits. That purchase purchasers should use the land further.
We got exhibits. We got exhibits. That is sufficient. Because the High Court has destroyed the exhibits.
Few exhibits are activating the series one and shall I read?
Where is the copy?
Only few sentences between that. About the derivation of hydrogen peroxide. Then we got 11 portion. Issue to ask the our father developer to reveal Satya article. He can schedule the events in the travel. ಸಾರ್ವಜನಿಕ ಉಪಯೋಗವಾಗುವ ಶಾಲಾ ಕಟ್ಟಡ ಹಿಂದೂ ಅನಾಥಾಶ್ರಮ ಬಗೆಯನ್ನು ಕಟ್ಟಿಸುವ ಸದುದ್ದೇಶದಿಂದ ನನಗೆ ಈ ಕೆಳಗಿನ ಶಕ್ತಿ ಮಾಡಬಹುದು ಎರಡನೆಯವರು ಸಾರ್ವಜನಿಕ ಸೇವೆಯಲ್ಲಿ ಸ್ಥಳಕ್ಕೆ ನೀರಿನ ವಿಭಾಗವಾಗಿ ಕಡಿಮೆ ಬೆಲೆಯಾದ ₹20,000 ನನಗೆ ಬೆಕ್ಕರೆ ಸಾಕಷ್ಟು ಬೇಡಿದ್ದಾನೆ. ಎರಡನೆಯವರು ಸಕ್ರಿಯತೆ ಮೊದಲನೆಯವರಿಗೆ ಇರುವವರಿಗೆ ಅದರ ಪ್ರತಿಫಲವಾದ ₹20,000 ಈ ಕೆಳಗೆ ವಿವರಿಸಿದ ರೀತಿಯಲ್ಲಿ ಮೊದಲನೆಯವರಿಗೆ ಸಹಾಯ ಮಾಡಿರುತ್ತಾರೆ. ₹10,000 ಈ ದಿನ ರಿಜಿಸ್ಟರ್ ಸಮಕ್ಷಮ ನಗರೀಕರು ₹10,000 ಇದರಿಂದ 5 ವರ್ಷಗಳಲ್ಲಿ ವಾರ್ಷಿಕ 5 ಕಂತುಗಳಲ್ಲಿ ಅಂದರೆ ಪ್ರತಿ ಒಳಗೆ ಅಷ್ಟು ನಗರೀಕರಲ್ಲಿ ₹2,000 ನಗರೀಕರ ನೇರನ ಬಡ್ಡಿ ಸಮೇತ ಕೂಡಿಸಿಕೊಂಡು ಸರ್ವಿ ಈ ಕೆಳಗೆ ಜವಾಬ್ದಾರಿ ಸಹಾಯ ಮಾಡುವುದರಿಂದ ಮೊದಲನೆಯವರು ಅರ್ಜಿ
So there is a condition in the sale.
Yes, condition between the purchase and vendor. The vendor requires this property should be utilized.
So subsequently, school was constructed in that property.
Husband now actually constructed school. He was earlier working as headmaster. After his retirement, he started school to give education to
So how do you overcome this admission of DW?
DW admits what is stated in the intention of orders purchase. No, plaintiff has to prove my order. But here intention of a person who purpose to the society or service to the society in his legal capacity. So it cannot be construed that it is for the purpose of public he has purchased it. But it is his intention that he should give some public method of service to the society. He should respect his school because he was headmaster at his school, who is a retired person. That's why this same gives the option kindly appreciate this same does not say that it was for the purpose of the institution it was purchased. It's not this. But money was not paid by the number 7 association. It was in existence as per the execution of DW1 in the 69 itself. Not even the single line was created in the safety. But the recital of the safety shows that the balance amount has to be paid within certain time of 5 years in interest. And now the recital of safety also shows there are the ಎರಡನೇ ಅವರ ಸಂತಾನ ಪರಂಪರೆ ಅನುಭವಿಸಿಕೊಂಡು ಆರಂಭಗೊಳ್ಳುವವರೆಗೆ ಒಂದನವರೆಗೆ ಫೀಸ್ ವಾಸ್ತವವಾಗಿ ಸಹ ಯಾವುದೇ ಸಂಬಂಧ ಬಾಧಿಸುವುದಿಲ್ಲ. It also speaks the purchaser and his successor will enjoy this property. Only condition is that the property is not used for the public purpose. The vendor will have the right to cancel this CD. This is the entire crux of Exhibit P1. Now, kindly appreciate. The CD is dated 17/1/1969. Interestingly, 17/1/1969 is the CD. PW1 says, 25/12/1968. 25/12/1968. The Sarkar Defend Number 7 was passed.
Defend Number 7.
Yes. I may refer it as Defend Number 7. 25/12/1968. PW1 said as the plaintiff number 1. Whereas this daily is dated 17/1/1969. After formation of this account. Not even a single reference in the same that Sanka is formed to declare the immovable property for construction of the school and thus it is purchased. Not even a single recited in this area. Then balance consideration was paid by the different numbers of different that is on 23/1974. But this will be a relevant aspect throughout the show. May request note this 23/1974 the balance consideration of this 10,000 was paid by defendant as per Exhibit D21. PW1 and PW2 says they were not aware when this balance consideration was paid, who have paid it. Then I distribute this for HRC proceedings for possession of this property. When HRC proceedings were distributed, the present suit came in picture who was not even resident of the state.
So page for the plaintiff.
I appear for respondent number 1 and 2. Respondent 1 has died, my lords. I think it's already recorded in the court proceedings.
Yes, whether the institution, whether defend number 7 has purchased the property.
Lords, respondent number 7 is represented by Mr. O.S. Bhatt.
You filed a suit, no?
Yes, my lords, I filed the suit. Now the case,
Must establish that defend number 7 has purchased property for the purpose of.
My lords, the suit property was purchased for the purpose of starting and running the school. My lords, your lordship will go through the plaint. Can I take your lordships to the plaint?
Yes.
The plaint averments are clear. My lords, para 2, can I read para 2? And some of the plaint documents are important, my lords.
Yes.
Well, some of the plain documents are also important. Exhibit P9, 10, 22, and 26, which the father of the appellants herein has clearly written to the DDPI, stating that this is the Sangha property.
So what the sale deed speaks about?
Malaj, the sale deed necessarily had to be done because the Sangha
It's a
had
foundation.
not. Malaj, it was a
That is the
conditional sale.
foundation.
It was a conditional sale, Malaj. Malaj, the sale could not
Condition
have
is
been.
not compliant.
Malaj,
Who is the aggrieved person?
Malaj,
Vendor.
Malaj, vendor may be, but this was purchased for the purpose of a public. There's a public interest involved. Now,
whether any amount was collected at the time of
yes,
purchasing?
Malaj, there's abundant evidence on record which shows that money was collected from the public. In fact,
pleaded in your plaint.
Yes, Malaj.
Where?
Malaj, the entire plaint. Your Lordship will see para 2. Let my can I take your Lordships to para 2? Malaj, as the first step, Malaj, I'll go through the whole plaint, Malaj, para 1 onwards.
Yes,
Malaj,
yes,
the entire pleading is this: the purchase of the property was
Sir,
from.
show me from your pleading that amount was collected from a public for purchasing this property.
Yes, Malaj, that's very clear. Malaj, para 1 of the plaint, Malaj. Can I take
Yes,
your Lordship? Yes, Malaj. Early in the year 1969, the father of defendants 1 to 6, namely B. Gopal Krishna Rao, since deceased, and his associates decided to establish a primary school at Padil of Alape village to provide education to the boys and girls of Alape Kannur village, which did not then have any primary school. These villages were which were then on the outskirts of Mangalore city are now part of Mangalore city. As the first step, the immovable property described in the schedule hereinafter referred to as the schedule property, was purchased ostensibly in the name of Lakshmi Devi, wife of B. Gopal Krishna Rao and mother of defendant 1 to 6 herein, under a registered document dated 28/1/1969 and styled as a conditional sale deed. Usually a sale deed is executed by the vendor alone, but in this case, since the sale was subject to conditions which was of very essence of the transaction, the ostensible purchaser also signed the deed so as to be bound by the conditions stated in the document. The registered conditional sale dated 26/1/1969 states that the purchaser desired to purchase the property to be used for public purpose of constructing a school building and Hindu orphanage, and that the vendor, being a social service enthusiast, he sold the property at the concessional price of ₹20,000, much below the market value of the property. The document further mandates that the purchaser should construct a school building and orphanage in the scheduled property within 2 years, and if the purchaser uses the property for any other improvements for their own benefit, the vendor shall be entitled to recover the possession of the property after paying back the price of ₹20,000 without interest and compensation for any improvement made in the property by the purchaser. The purchase of the property was followed within a week by forming a society named Adarsh Vidyavardhaka Sangha by a memorandum of association and rules and regulations of the society signed on 4/2/1969 by B. Gopal Krishna Rao and his associates and the founder members, and with Gopal Krishna Rao as the president of the Sangha. The application for registration of the society was forwarded to the Registrar of Societies at Bangalore. Having regard to the procedural requirements and formality that had to be fulfilled to the satisfaction of the registrar at Bangalore, the certificate of registration of the society was issued on 15/5/1970. The purchase of the scheduled property in the name of Lakshmi Devi, wife of B. Gopal Krishna Rao, under a conditional sale deed dated 28/1/1969 and the formation of Vidyavardhaka Sangha on 4/2/1969 and the registration of the Sangha were all parts of one project, namely the establishment of a higher secondary school at Padil in Alipe for the benefit of providing education for the children residing in Alipe and Kannur villages. The result is a constructive trust of public charitable purpose for providing education to the boys and girls residing in Alipe and Kannur village. These two villages are adjacent villages to either side, and from registered conditional sale deed dated 21/1969 from the registered conditional sale deed dated, it does not appear that the vendor intended to transfer the beneficial interest, and the ostensible purchaser has no beneficial interest in the scheduled property. Lakshmi Devi, the mother of defendants 1 to 6, was a constructive trustee, and on her death, her legal defendants 1 to 6 are constructive trustees. Meanwhile, following the conditional sale deed and registration of the Adarsh Vidyavardhaka Sangha, the construction of the school building as a scheduled property was taken up. The needed funds was raised by donation made by the ostensible purchaser's husband and the donations collected by him from the public from time to time, for which he toiled going from house to house. And the school named Adarsh Vidyavardhaka Sangha was started in the year 1970-71, and further collection of donations from public from time to time and construction of additional building on the scheduled property. A high school named Adarsh Bharati High School was started in the year 1981-82. Now the higher primary school has students strength of over so and so. Malads, para 7 Malads.
Yes, read.
Gopal Krishna Rao, father of defendants 1 to 6, continued to be the president of Adarsh Vidyavardhaka Sangha up to the year 1977, and thereafter secretary of the Sangha up to 1985. He was the correspondent of the school from 1970 to 1985, managing all the affairs of the Sangha and the school. For some time, he was also the headmaster of the school and teacher. So long as Gopal Krishna Rao and his wife Lakshmi Devi were alive, the conditional sale deed was honored and the constructive trust was not repudiated. The plaintiffs are 2 residents of village and their children are students in the Adarsh Vidyanilaya school. The silver jubilee of the Adarsh Vidyavardhaka Sangha was celebrated on 22/2/1979. The plaintiffs were among the donors who contributed to the silver jubilee fund and have given a given the souvenir brought out in the occasion, and the copy of the annual report of the Sangha related to the year 1996-97 dated 2/11/1997. Copies of the annual report of the Sangha were given only to members of the Sangha. The plaintiffs, not being members of the Sangha, have not received any previous annual report of the Sangha. From the annual report dated 2/11/1997, the plaintiffs became aware for the first time that the children of Gopal Krishna Rao, namely defendants 1 to 6, who are the appellants before your lordship, had filed application against the Sangha under the Karnataka Rent Control Act for recovery of possession of the scheduled property.
So
On making
read the relevant portion to show that by public fund property has been purchased.
Malads, there will be two sets of contributions, Malads. One is at the time of purchasing the property.
Secondly, I'm
Secondly,
asking the same thing. I'm asking you, at the time of purchasing the property, father of defendant number 1 to 6 has collected a fund from the public.
yes, Malads. Malads, now your lordship will see the property was sold at a concessional price. That itself is a contribution. That is established in the evidence on record. Malads, the document.
Transfer of Property Act.
Yes, Malads.
Read section 10 of Transfer of Property Act.
Yes, Malads. I'll just. where a property is transferred subject to a condition or limitation absolutely restraining the transferee or any person from claiming under him from parting with or disposing of his interest in the property. The condition or limitation is void, except for in case of a lease, where the condition is for the benefit of the lessor or for those claiming under him, provided that the property may be transferred to or for the benefit of a woman, not being a Hindu, Mohammedan, or Buddhist, so that she shall not have power during her marriage to transfer or change the same or the beneficial interest therein.
What do you say?
Well,
any conditions imposed in the sale deed will become void under section 10 of TP Act.
Yes. Well,
moreover, first you must establish that you have got a locus standi to file a suit.
Well, as a resident, I'm entitled to file a suit under
If
section.
a property was purchased out of public fund, then you will get a right.
Well, the documents on record, exhibit P9, 10, 22, and 26. Those are letters written by none other than Gopal Krishna Rao to the DDPI saying that the Sangha has acquired property. This clearly establishes at an undisputed
point. In existence since from 1968.
Yes, Paul.
Why property was not purchased in the name of defendant number 7?
Well, because the Sangha was constituted after the sale.
Yes. Yes.
Now, exhibit P22, Gopal Krishna Law clearly states that the Sangha has acquired property. Similar narration by him in the letter written to the DDPI in exhibit P9 and P10.
But how are rights transferred?
Well,
section 17 of 59.
Well, that is why the pleading is regarding that it forms a constructive trust.
Yes. Yes. Yes.
Yes, Pranav. Well, my submission is when a property has been purchased for a purpose which could not have been envisaged at the time of, which was envisaged at the time of purchase, but could not have been transferred or purchased in the name of the intended user, which is this, which was a Sangha, which had not been registered as on that date. It necessarily had to be purchased in the name of another person who holds it in trust for the Sangha. Nonetheless, the Sangha was admittedly constituted after the purchase of the property. The intention of the purchase was to form the school. That intention is clear from the sale deed itself in two aspects. One, that a school has to be established on the said property. And secondly, that the sale consideration itself was split. The reason for the splitting is not because the sale deed could not have been purchased, but that the funds for the said purchase would come out of running out of the school and from the other collections which are made from time to time.
Are you a vendor?
Malaj?
Are you a vendor?
I'm not the vendor, man. Your Lordship, Malaj, your Lordship is asking me whether I'm an aggrieved party. I'm only aggrieved as a resident of the area that a particular property which was intended to be used as a school property.
Correct. If a property was purchased by a defendant number 7 out of public fund, then you get a right to challenge. This is a private sale deed in between Lakshmi Devi and a vendor.
Malaj, my submission is when a trust is constituted for the benefit of the public at large,
Trust has not purchased this property.
My case is that it was purchased out of for the benefit of the public.
Yes.
That is my pleadings.
Yes.
And my submission is that when something is purchased out of public for the purpose of a public utilization, every member of the public has an interest in seeing that the property is not devolved onto somebody else. And
Yes.
that is my
Yes.
my submission is your lordship will have a look at exhibit P9, 10, 22 and 26, which clearly shows that the property was purchased
All
for
the
and on behalf.
exhibits,
Yes,
all the exhibits are already destroyed by the trial court.
can I suggest I can reconstruct from what I've got, my lords? I've got photocopies of the.
Produce the copies tomorrow.
Tomorrow may not be possible, my lords. Your lordship may have it on Friday or Monday, my lords.
Sorry, sir, I already heard the matter.
Very well.
Tomorrow, at the request of Lord Appellant for a response. What is your contention, sir? Go for defend number 7. So you are supporting.
My lord, serial number 37. My lord, serial number 30.
So wait for some
Serial
time.
number
36
Please.
is going on.
Please.
Supported the plaintiff.
He was one of the
When a property was purchased, whether trust has contributed for purchasing the property. Sir, you answered the court question. Whether the trust has contributed only after purchase. It was registered in the year 1970.
Balance consideration was paid on 1974 by the defendants. 74 only, but then it was sufficient. Even if their contention is to be accepted of the trust was registered. 4 years there was no impediment for the trust to pay the balance consideration that was made by as per exhibit 21.
Number 37, CBRL. Yes, the number for the respondent. PV Srinivas. PV Srinivas, V Anand. Serial number 37.
Appearing for the appellant, Your Lordship. Your Lordship may kindly grant 2 weeks of time, Your Lordship, since senior advocate.
7.
Apologies, Your Lordship. Will kindly have it after 2 weeks. Any date after 2 weeks may be fixed, Your Lordship. Senior advocate is.
You want to argue the matter, argue, otherwise the court will go through the report and will pass a judgment.
Your Lordship,
That is of year
any week.
2007.
Apologies, Your Lordship. Any week next time is any week. Anytime next week is all. Your Lordship may kindly have it next week, Your Lordship. Apologies.
Rights have been acquired. The first rights have been acquired. Remember, these are the aspired owners. Defendants are the aspired owners. Plaintiff is the public and private employees. Whose favor the rights are acquired. The 62 notification, portion is added over, amount is deposited. And the acquisition proceedings are also challenged. In petition 32714, that also is discussed. Interview number 1201 of 2021. That is also discussed on 47/2020. And revenue records in the name of the trust. The defendants are registered owners.
Okay, year 2007. So, one more question. If you want to argue the matter, court will go through the records and will pass on.
Your Lordship may kindly pass over the matter, Your Lordship. The senior is engaged in the other court, or Your Lordship.
That's it.
Senior number 39, Shri B.N. Malaswamy. B.N. Malaswamy. He had bought a property after the agreement is the contention is that
Date of agreement. Date of agreement. 28/9.
28/2000.
So the time fixed for execution for registered salary.
Within 1 year.
When a suit was filed.
Immediately after my lord, we got it 27/8/2002. The rated dependent number on executed basis. Issued petition 4/2002. and 2009 get by the 2.
2003 suit was filed in the year 2003. 2310.
$60,000. That was determined. Therefore, this suit was very subjective. That is not the admittedly, it was a loan transaction. What I said in paragraph 22. Paragraph 2. The dependent on the owner of the subject property agreed to sell the subject property to the paper when we issue a notice, can we see the written notice at HTTP? This is very important.
You will read the pleadings which is favorable to him. Not taking. You point out it.
The event number is committed the breach of contract is going to be removed. But both the defendants got admitted was subsequently clarified. Subsequently, contract was admitted accordingly including account patient for 250,000 without realization. The defendant not acted according to contract is not being
Continue 230.
ಸ್ಪೇಸ್ ಅನ್ಕೊಡ್ಬೇಕಂದ್ರೆ ತಗೊಬೇಕು ಅಂದ್ರೆ ಹಂಗೂ ಮಾಡ್ಬೇಕಂದ್ರೆ 3 ತಿಂಗಳು ನೀನ್ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡ್ಬೇಕು, ಅಲ್ಲಿಂದ ನೀನ್ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು, ಲಾಯರ್ ಇಟ್ಕೊಳ್ಬೇಕು, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ನಡೀಬೇಕು, ಆಮೇಲೆ ಜಡ್ಜ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು, ಇಂಜೆಕ್ಷನ್ಗೂ ಸೆಟಸ್ಗೂ ಏನೇನೋ ಹೇಳ್ಬೇಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ Court officer.
ಬರುತ್ತೆ ಅಂತ ಇದು ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತದೆ. ಮೊದಲೇ ಮಾತಾಡೋಣ.
Hello.
ಅವ್ರು ಕಳ್ಸೋದು ರಾಂಗ್ ಅಡ್ರೆಸ್ ಅವ್ರ ಮನೆಗೆ ಸೇರ್ಬಾರ್ದು.
ಅವ್ರ ಮನೆಗೆ ಹೋಗ್ಬಾರ್ದು, ನಾವು ಮಾಡಿದೀವಿ ಅಂತ ಕಿವಿಟ್ ಆಗಿದ್ದರಿಂದ ಗೊತ್ತಾಗಬಾರ್ದು. ಅದು ಅದೇನು ಕೋರ್ಟ್ ಗೊತ್ತಾಗಲ್ಲ. ನೀನ್ ಕೇಸ್ ಹಾಕಿದ್ರೆ ಕಿವಿಟ್ ಹಾಕಿದ್ರೆ ಅಂತ ಗೊತ್ತಾಗಬಾರ್ದ್ರಿ. ನಾವ್ ಹಾಕಿರೋ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ ಮಲಗಿರ ಅವನೇ
Court officer.
ಲಾಯರ್ನಿಗೆ ಕೊಡೋದು, ವಕಾಲತ್ ಹಾಕೋದು, ತಕರಾರು ಆಗ್ತೀವಿ ಅಂತ ಹೇಳೋದು, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನೋಷ್ಟಕ್ಕೆ 1 ತಿಂಗಳು ಆಯ್ತದೆ. ಅಷ್ಟೊಳಗಡೆ ನೀವೇನ್ ಬೇಕೋ ನಿಮ್ ಕೆಲಸ ನೀವು ಮುಗಿಸ್ಕೊಡಿ. 1 ತಿಂಗಳೇನು 6 ತಿಂಗಳೇ ಹೋಗ್ತದೆ, ಅಷ್ಟೊಂದು ಹೋಗಲ್ಲ. 1 ತಿಂಗಳು ಬೆಳಿಬೋದು. ಕಿವಿಟ್ ಹಾಕಿರ್ತೀವಲ್ಲ ಬೇಗ ಅಲ್ಲಿ ಆಫೀಸರ್ ಮೇಲೆ
Court officer.
90 ದಿವಸವರೆಗೂ
Court officer.
90 ದಿವಸ ಆದ್ಮೇಲೆ ಬೇಕು ಅಂದ್ರೆ ತಿರುಗಿ ಇನ್ನೊಂದು ಕಿವಿಟ್ ಹಾಕ್ಬೇಕು. ಕಂಟಿನ್ಯೂಷನ್ ಬೇಕು ಅಂದ್ರೆ
Court officer.
ಅದರ
ಸರ್ ಸಪೋಸ್
ಆಗ್ಬಿಟ್ರಿ
ಮಾಡ್ಬಿಡ್ತೀನಿ ಆಗಷ್ಟು ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಹಾ
ಆದ್ಮೇಲೆ ಅವರು ಏನಾದ್ರು
Court officer.
ಸರ್
ಹಾ ಓಕೆ ಓಕೆ.
ಹಾಕ್ಬಾರ್ದು ನೀನು ಅಂತ ಇಲ್ಲ.
Court officer.
ನಿಮಗೆ ರಿಲೀಫ್ ಸಿಗ್ಬೇಕು. ಅದೆಲ್ಲ ತಗೊಳ್ಬೇಕು. ಊಟ ಸಿಕ್ಕಿದ್ರೆ ಗ್ಯಾಸ್ ಹೋಗ್ಬೇಕು. ಏನು ಸಿಕ್ಕುದ್ರೆ ಸಿಕ್ಬೋದು ಅಂತ ಹೋಗ್ಬೋದು ಕೆಲವರು. ಏನಿಲ್ಲಪ್ಪ ಅಲ್ಲ
ಹಲೋ ಹೇಳಿ ಸರ್. ಹಲೋ
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ
ಸರ್? ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಯು ಆರ್ ನಾಟ್ ಆಡಿಬಲ್ ಸರ್.
ಅಂದೆ
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 39 ನಡೀತಾ ಇದೆ ಸರ್. ಮುಂದೆ ಯಾವ್ದ್ರದ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಮೇಡಮ್ 28 ಏನಾಯ್ತು ಮೇಡಮ್?
ನೀವ್ ಯಾರು ಮೇಡಮ್? ಅಡ್ವೊಕೇಟಾ?
ಹೌದೌದು ಮೇಡಮ್.
ಹೌದಾ? ಅಲ್ವಲ್ಲ, ಏನೋ ಹಾಕೊಂಡಿಲ್ಲ ಬ್ಯಾಂಡು ಫೋಟೋ ಎಲ್ಲ.
ಮೇಡಮ್ ಈಗ ಬಂದೆ, ನಾನು ಕೋರ್ಟ್ ಇಂದ ಬಂದೆ. ಅದು ಪಾಸ್
ಓವರ್ ಆಗಿದೆ.
ಹಾ ಗೊತ್ತಾಯ್ತು, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಮೇಡಮ್.
ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ಆಫೀಸ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಹೌದು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಓಕೆ.
Court officer.
ಹೇಳಿ ಸರ್.
Madam, serial number 37 madam, list number 1. ಏನಾಯ್ತು ಮೇಡಮ್?
ಪಾಸ್
ಅರ್ಜೆಂಟ್
ಓವರ್
ಆಗಿದೆ.
ಆಗಿದೆ ಸರ್. ಕರ್ದೆ ನಾನು, ನೀವಿದ್ರಿ, ಜೋರಾಗೆ ಕರ್ದೆ. ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಹೌದಾ? ಸರಿ ಸರಿ. ಅದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ ಅದಕ್ಕೇನೆ?
ಅವಾಗ ಅವ್ನು ಎದುರು ಮಾಡ್ಕೊಂಡು ಆಡ್ಲಿ, ಕೋರ್ಟ್ ಆದೇಶ ಐತ್ರೆ ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ನಾನು ಕೊಡ್ತೀನಿ.
Wait. Yes.
That was also dissolved. The great mistake I am not going to what they have before that if they were given better depending number of page 47. If you got page 47.
Yes.
What are the returns of the dependent number of page 47? This is ಪ್ರಮಾಣದ ಹಣದಿಂದ ಪ್ರಾರಂಭವಾಗಿ ಈಗ ಬರಬಹುದು ವರ್ಷದಲ್ಲಿ ನನ್ನ ಪ್ರತಿಯೊಬ್ಬರು ಪ್ರಮಾಣದ ಬದಲಾವಣೆ ನನ್ನ ಬಗೆಯಲ್ಲಿ ಕೇಳಿದರು ನನ್ನ ಪತಿಯವರಿಗೂ ತಮ್ಮ ಪತಿಯವರಿಗೂ ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದೀನಿ ಅನ್ನೋದು ಅವರಿಗೆ ಮನೆ ವ್ಯವಹಾರ ಮಾಡಿರಲಿಲ್ಲ ಕೂಡ ಓದೋದಕ್ಕೆ ಆಗಲಿಲ್ಲ ಏಕೆಂದರೆ ಬಹಳ there is a financial transaction between the husband and his husband. This is a document which was prepared by the bailiff and which has been said that he has not used it. This agreement, the fact paper was purchased previously by the husband of the father. The article they only requested for sell the property and I refused and I facilitated for sale in favor of the second because that's the difference. Now when you see this difference statement. What they have paid the stamp at parallel.
Page number 10.
The one of the transaction which is not included in the that time only the property last time that property as nominal agreement has been executed and soon after the payment of the cancelled. When the suit agreement will try to see what he says here not to fit to the agreement he said. That was the document was prepared by the plaintiff. Here he says a nominal agreement was executed. Then it goes on changing from case to stage take the loan. Only a nominal agreement. There is no conflict of point between the institution and the payment. No amount of sale allocated. Even after some time, the state will not retain the land, so they are
Yes.
But in fact, it was instrumental role, instrumental getting the property to the second defendant. After sale, the property to the second defendant took place in the house of the plaintiff, and in the course, in the presence of the plaintiff and the respect between the agreement was executed. If I have the signature denial, then the cancel the regular registered agreement of the plaintiff. So after the last of the sale, the property was now, they say that even the second defendant says it was at out of the plaintiff. There is no impediment for them to get a state sale agreement cancelled. That's a registered agreement. What is this is a contradictory evidence. He says in our state of sale tax took place in the house of the plaintiff to the defendant number 1. The defendant number 2 says it was in May 2000 state tax agreement. To show that there is other financial transaction, nothing, no document has been produced by the defendant. Evidence okay. Yes, that because there is a section, because in order to discharge the loan amount, you already introduced one of them, and that paragraph 23 as adjustment. The unit state of the basic of the income of the that transport agreement of sale this is not a case. The agreement of sale was much earlier. This was after the notice and there was a matter to what that background agreement of sale this was happened in the year 2003. This whatever matter because they after the issue the notice to them.
Yes.
Here also paragraph 21. The signature of the defendant and the respect of the agency were not in dispute. There is no dispute in respect of the agreement. If changes and WFC was nominal agreement in the case, the answer is that you can go the process that is taken apart. That process that is carried out. Okay, the audio of the Dava and Manhattan Manhattan This is what your reference page is in page 111. This is subsequent to the agreement subsequently he has informed that I will repay the money. It was not even that. Maybe I will take the page 111 it will be page 111. This is a private company which are required to the works there. Secondly, the factory 13. For the bottom 112. After began last to relate. After began to another one, those were all of the price another media. This was subsequent to the notice and all those things. This is what we can do. Subsequent to that, the worker is there, and the good to attend the other 2003, whereas my notice is as 2002. This is subsequent to this 2003. 2003, this patent was it. They don't get upset from the terms of the contract. They have to follow the point. Because this check was issued, that was not honored by the defendant. The stack taken by the plaintiff, defendant number 1.
You are paying for defendant of the
Yes.
purchaser. What is your stand?
This is a regional litigation. What is the cause of action for the suit process? Demand and refusal is the cause of action for the suit. In the margin here, arrow number 6. The prayer itself says, degree for specific performance directing the dependents to execute. Your Honor, you must be able to see arrow number, page number 5, paper. Prayer. For specific performance, the contract as per the terms, the actual ticket, directing dependents to execute the registered saving to receive balance of sale of specific here, beginning to do so, what will please do? Execute the registered savings. So he is asking if this is fully done. Second, alternative, for treatment of the advance to actually these are the two. Prove that after the exchange of notices, lodging at any stage, there was a check issue on 2-3-2
The defendant has acted upon that. Defendant number 1 has acted upon.
At the agreement, it is an admitted fact I have told from the records from the year ago that this agreement was executed in lieu of some payment which was due by the husband of the first defendant to the husband of the first defendant.
Read the contents of recital of agreement.
Yeah, agreement at page number 35. It simply says that it is for 725, 2 lakh is paid. No, what should I say? Even according to the income tax act, no amount below 20,000 rupees can be paid with cash. If at all he wanted to secure this payment, he should have made it by a check. Account by check.
It's a registered document.
Registered document. But he says 2 lakh is paid. The contention is 2 lakh is not paid. This document was
It's
executed.
Section 91 of the Evidence Act. 91. So there can be any oral evidence content to the.
No, I don't insist upon that. I want the other part. So,
Why is you are arguing the matter?
I'm just arguing. You can argue anything, written document.
It is a written document. It is a registered one.
No, my contentions are like this one. First, when we come to page number 90.
90.
90.
Yes.
Receiving the income certificate I have obtained before purchasing the property in first date. The period for 13 years, one from 1990 to 1982, 2002. Plaintiff agreement of sale is 28 2001. My sale is 28 7 2002. Subsequently only, after say about 1 week thereafter.
It is a registered agreement of sale.
Registered agreement of sale.
So there has to be an entry in the income.
Entry in that. But somehow it is not there. I don't know why they acted upon that. Now the other side argues that no document is produced to show that there was a financial transaction with the next document. Exhibit D7. We have some payment which was due by the husband of the first event, who is the husband of the lady. The document of sale was that. And we have also entered upon the subsequently, when the exhibit after the money was received, when exhibit D7 is cancelled. Exhibit D7 on the agreement of sale of the purpose, who was the exhibit D8 exhibit money as a cancelled. So also here, if 2,60,000 was paid, when the first event date was reflected, this would not have. Because the money was not paid, he doesn't even go to after exchange of we are supposed to have. In the plain, they also have mentioned about the private complaint. I want to the check was dated 2/2003. Thereafterwards, a notice was issued on 4/2002. Personal credit. 4/12/2002, demanding for payment of 2,60,000. So, he gives up the agreement.
Where is the
He
notice?
is not insisting upon the agreement.
Where is a copy of notice?
Copy of the
Notice.
notice.
Page number?
Although, extent that is the notice issued demanding for specific performance. I am speaking about the private complaint notice issued on the date notice. In fact, in the suit, he ought to have mentioned that there was a settlement, but in furtherance of that number 6 participating the party state. In furtherance of that, we have issued a notice also. For that notice, there was a term of reply. Thereafterwards, I have paid a PCR, but return of the money in PCR number 296 of 2003. This was filed on 28 for 2003. Much before this suit is filed in October. Even in the PCR, since they did not any more of this PCR 296 of 2003 is filed under section 138 of the Universal Dispute Act. Only plaintiff as complainant, against the first amendment will be accused. In the first section dated 2003, this complaint is filed on 28 for 2003, much before the suit. And this is when the suit is filed. Suit is filed in 23/10/2003. After the even after the exhibit seeking notice and reply dated 29/12/2002, there is about 10 months we are planning this. Within 1 year, they don't make any efforts at all.
The period of impatience of filing the suit.
No, you need not wait 3 years. 3 years is more. Go the law prescribes 3 years for filing. At the earliest point of filing, you have to rush to the court. Otherwise, this is a discretionary relief. Then you can't ask the court to exercise the discretion in your favor. At the earliest point of time, you have to come to the court. For 1 year, there is no exchange of notice. It doesn't say, I am ready with the balance of self-consideration. What happened to your release of the documents? What you had agreed to release from your financial? Anytime I am ready to pay, I am ready to buy. And even in the brain there, we are making an allegation that plaintiff was ready and willing. It's not sufficient. You should say, I have got immovable properties like this. Then I can raise some money. You need not deposit the cash before the court. Or show the money, financial capacity before the court. But you need the difference at least. Tell that I have got immovable properties, immovable properties. I could have raised the balance of self-consideration. You should elaborate. Not in the plain. In the plain, only he was ready and prepared to take the safety that is the general allegation. But even you have to elaborate and say this was available for this was immovable property. I could have raised some money for purchasing the property. 1 year you don't do anything. After 1 year, when I sell the property to another person, then the first defendant sells the property to the second defendant, then he issues us the notice. Even after the notice, immediately he doesn't go to the court. He waits until the PC has said, then he calls upon the first defendant for settlement also to mediators. There was a settlement. What does the settlement indicate? Settlement indicates that
But that has not acted upon. It has not acted upon. The defendant number 1 has acted upon.
No, then the purpose of the agreement, the plaintiff has not at all acted upon. Moreover, they have
Settlement was in between plaintiff and defendant number 1. Defendant number 1 has to pay the amount of rupees 2 lakh. Has he paid the amount?
he has not paid.
Then who has not acted upon? Defendant number 1 has not acted upon, not plaintiff. Defendant number 1 was to perform his part of contract.
He better to be just what? Then he has to file a suit for recovery of the money against the first defendant.
Yes.
Because you have given up the agreement, you are not passing the agreement. What does the settlement indicate? Now it's going to be a court, now I am legal to papers. He wants money.
Suppose in cases the defendant number 1 has acted upon the settlement, then it amounts to giving up of his claims.
No, the mere fact that the agreement, I'm sorry, mere giving up to your claim for specific performance and acting upon the defendant that he wants only the money, itself amounts to giving up. So we'll come to the other documents also. Very right. Here is the page number 111, 59. This is the PCR. Should I not show he is the plaintiff? He has come to the court seeking leave to the police law. Should he not mention about the pending proceedings at this? In the plain, now there is what has to be written is there are no proceedings taken to the parties in any other court, any other taken out that we have to pay.
Not in the plain. Please read order 7 rule 1. Order 6 no odi, 7 no the contents of pleadings there should not be any clause in the pleading that plaintiff has not filed any suit or has not exhausted any alternative remedy. That will be there. Only in the requisition they will take a stand, not in the suit. Order 607 over this. ಅವ್ರು 7 rule 1 ಓದಿ. ಇದೇನಾ ಫಾರ್ಮೆಟ್ ದಲ್ಲಿ ಅಲ್ಲಿ ರಿಪಿಟಿಷನ್ ಫಾರ್ಮೆಟ್ ದಲ್ಲಿ ಬರ್ತದ ಅದು, ಪ್ಲೇನ್ ದಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅದು. ಇನ್ನ ಎಷ್ಟು ದುಡ್ಡು ಬೇಕು ಹೇಳ್ರಿ ನಿಮಗೆ? ಆಯ್ತು ಅದು ಬಿಡಿ, ದುಡ್ಡು ಇನ್ನ ಎಷ್ಟು ಬೇಕು? ಎಷ್ಟು ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಬೇಕು ಅಷ್ಟೇ. Then we'll discuss it. Yes. ಆಯ್ತು ಗೊತ್ತಿದೆ, ನಾನು ಅದಕ್ಕೆ ಕೇಳಿದ್ದೇನೆ. ಎಲ್ಲ ಇನ್ಕಮೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ಸೆಕ್ಷನ್ 55 ಆಫ್ ಟಿಪಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಓದಿ ಅನ್ಸುತ್ತೆ. Before purchasing the duty of section 55 of TP Act ಏನು ಹೇಳುತ್ತೆ? Rights and liabilities of the buyer and seller. Now defendant number 2 has already invested huge amount. That is the reason why a specific performance was not granted by the trial court. Excess amount ಬೇಕಾದ್ರೆ ಇಸ್ಕೊಡೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ yes. This is the evidence of the defendant number 2. This is the evidence of the defendant number 2. 84. So, after leaving some 4 or 5 lines. ತಿಂಗಳಲ್ಲಿ ಎರಡನೇ ವಾರದಲ್ಲಿ ಮಾಡಲಾಗಿದೆ. This is what they are proof that of this is inconsistent standard. What is normally
mean, they have done they would have cancelled the this is what they want to produce not easily. Definitely to show that without making that state transaction, they have bought from easy and they have produced before the code. We are also doing the same thing, you know, to have a system like the amount was not paid. Even that was as per the terms of the settlement, that was the PCC alone.
Yes. Yes. Yes, sir. If the plaintiff received a reply notice, when plaintiff received a reply notice, when a suit was filed, 23/10/2003. Why suit was not filed immediately after receiving a reply notice? Yeah, 2008 Supreme Court 1786. Yes. Yes, read it.
Because this is not the only case, but there are several cases which are pending and both are dependent upon one and the husband. Yes, and telephone supervisor writing a case. ಎರಡನೇ ಸಾಲಿನಲ್ಲಿ ನಮ್ಮ ಅಂಗಡಿಯಲ್ಲಿ ನಷ್ಟವಾಗುತ್ತದೆ. ಅದೇ ಅಂಗಡಿ ನನ್ನ ಮಾವನವರ ಹೆಸರಿದ್ದು ಅದರ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದು. ಸದರಿ ವ್ಯವಹಾರದಲ್ಲಿ ನಮ್ಮ ಮಾವನ 40 ರೂಪಾಯಿ ಬಂಡವಾಳ ಆಗಿದೆ. ಸದರಿ ವ್ಯವಹಾರದ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಇರುವುದು. ಯಾವುದೇ ದಾಖಲೆಗಳಿಗೆ ಸಹಿ ಮಾಡುವಾಗ ಓದಿ ಸಹಿ ಮಾಡುತ್ತೇನೆ. ನಾವು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಬರೆದು ಕೊಡ್ತಾರೆ ವಿಷಯವನ್ನು ಮನದರ್ಥ ಮಾಡಿಕೊಂಡು ನಂತರ ಸಹಿ ಮಾಡುತ್ತೇವೆ. ಯಾವುದೇ ದಾಖಲೆಗಳಿಗೆ ಸಹಿ ಮಾಡುವ ಒಳಗಿನ ಸಂಗತಿಗಳನ್ನು ಓದಿ ಸಹಿ ಆಗುತ್ತೇನೆ. ನಾವು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಬರೆದುಕೊಂಡು ಯಾವುದೇ
Registered agreement for sale is moved. Then why unnecessary you are arguing the matter? Only whether trial court has exercised the discretion under section 20 of Procedural Act, judicially or not, that is a question to be decided. Unnecessary you are arguing the factual aspect. Which is
Regarding that, different work. The correct information around I have the patent that the rest of the agreement determined. Also, we are also same account. And after that, we also need to agreement to sell the turbine and engine. We must accept the different thereafter the says the life notice that was produced to the amount was received in the profession not be considered as a whenever the contract is registered agreement of stage. Right after the solution solution the same transaction is taken. That is the reason why stand up
This judgment will be applicable only if a defendant number, if a trial court has recorded a finding that the plaintiff has not proved the agreement of sale. Here, trial court has recorded a finding that plaintiff has proved an agreement of sale. We unnecessarily want to rely upon that judgment. Now, only under section. Why trial court has declined to grant a specific performance? Kindly come to paragraph number. Only on the ground that defendant number 2 has invested in amount. For that reason, trial court has refused, declined to grant a specific performance. Come to para number 22. Read para 27 of the impugn judgment. Please read issue number 1. They have not recorded a finding. While exercising the discretion under section 20, most court must give a judicial find the Supreme Court has held that while exercising the discretion, court should take into consideration the circumstances of the case and the conduct of the party and their respective interests under the contract. The trial court has recorded all these findings. ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ಕೇಳ್ತಾ ಇರೋದು, ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇವೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಾ? ಆಯ್ತು, ತೋರಿಸಿ ಎಲ್ಲಿದೆ. ಪ್ಯಾರಾ 27 ಅಲ್ಲಿ ಬಿಟ್ಟರೆ ಬೇರೆ ಏನು ಇಲ್ಲೇ ಇಲ್ವಾ? ಇಶ್ಯೂ ನಂಬರ್ 1 ಏನ್ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ, ಇಶ್ಯೂ ನಂಬರ್ 2 ಏನ್ ಇಲ್ಲೇ ಇಲ್ವಾ? ಎಲ್ಲಿದೆ ಆನ್ಸರ್? ಇಶ್ಯೂ ನಂಬರ್ 1, 2, 3 ಕರೆಕ್ಟ್ ತೋರಿಸ್ಕೊಡ್ರಿ. Otherwise, I'll allow the appeal on the basis of our records, because this is a first appellate court is the last fact-finding court. Court has not answered the issues. Show me a single sentence that he has collectively passed an order on the issues. So this is the way the trial court should answer issues. Whether issue number 1 is answered in affirmative or negative.
The need for the other options. It is not the agreement. And status are just waiting for us to complete the argument. Even in the vigorous import aspect of also, you can't one anything. Yes. That's what can you come over? That's what I wanted to hear. Take them up like you. Because most of the money is the answer.
Modi.
Number 32. What was last smoking this is supported by the other labels. Only this. You can't get here and there.
The trial court has discussed all these things in the.
This is covered. In the judgment, this is page number 21. Two more sentences. I just read one more sentence.
There any chances of settlement instead of remanding the matter? After arguing for some time, the net counsel for the party submit that they will explore the possibility of settlement between the parties. That will be listed on Friday. ನೋಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ Learner pays for the appellant, call and speak.
Number 40.
The old saying in English, the rubber band will be effective only when it is punched. Oh, change of advocates, number of alternatives, that is being time and again being observed. Time and again.
Just go to one again.
That's a happy note. Happy note.
The request of learner counsel for the appellant. Let the appeal be listed on Friday.
Number 41.
One fourth seal is already been ordered and again you waste time. Yes, so they propose a compromise.
Password.
Channel. For number 1. Serial number 43. CH-20. Serial number 44.
In this case, I am appearing for respond number 1, my lord. Respond number 1 died on 7/1/2018, my lord.
Learned counsel for respond number 1. Respond number 1 died on 7/1/2018. This submission is placed on record. Learned counsel for the appellant seeks time to file a necessary application to bring the LR. This is respond number 1. 2 weeks time granted to file a necessary application.
Number 45, CH-20, Vinayaka.
Your Lordship, I appear for the appellant. I pray for a week's time, Your Lordship. I'll make my submissions.
Velvania for R-7010.
The request of Learned counsel for the appellant.
Number 46, CH Jagdish, MD Agile. TV Muralidhar for respondent.
Cannot act upon the leisure of advocate. Argue the matter is of 2011. The request of Learned counsel for the appellant.
Your Lordship, I appear for the appellant in this case. Senior is not keeping well. A week's accommodation.
Request of
Serial number 48, NJ Ramesh.
ಏನ್ ಮಾಡ್ಬೇಕು ಅಲ್ಲ ಒಬ್ರು ಮೈ ಹುಷಾರಿರೋದಿಲ್ಲ, ಒಬ್ರು ಪಾರ್ಟಿ ಸತ್ತೋಗಿರ್ತಾನೆ, ಒಬ್ರು ಬೇರೆ ಕೋರ್ಟ್ದಲ್ಲಿ ಎಂಗೇಜ್ ಇದ್ರೆ ಈ ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ಬೇಕು?
I'm appearing for the appellant, Mara. This matter is ready, and I have already filed a synopsis that will be sufficient for the court to decide. I have already submitted a synopsis on September 2020. It went up to Supreme Court. Supreme Court has decided.
Yes, what a personal inconvenience and what the court should do now. Huh?
By 8/9/2021, I filed a synopsis that will be sufficient because it's already decided by the Supreme Court. The dispute is already decided by the Supreme Court. Between the same parties, between the same property.
When you have filed the synopsis, sir?
On 8/9/2021. Detailed synopsis was filed. 8/10. September. May I read? It went up to Supreme Court. Supreme Court has decided.
Lord, if I succeed, my lord, my learned friend, Lord, I am sailing together. Rosh, my lord, is everything depending upon my learned friends, my lord.
request of learned counsel for respondent.
May date maybe may.
Start date may fix.
12th July.
Huh?
12th July. Next Tuesday, sir.
Much obliged.
Ask over. Serial number 2. She gave in agreement.
Adnoda. Arena.
Serial number 2. Passed over matters.
Based on the paper that listed on
8th July. Serial number 3. Shri Sheshagiri.
the concept of appellant subject that is carried out amendment in the body of the appeal meaning the submission is placed on report. Let the appeal be listed for final hearing on
13th July. Serial number 9. Shri S. Maruti.
purpose on the paper the parties. Let the appeal be listed on final hearing.
13th July. Serial number 12. Shri V.V. Sidramaya. P.N. Hegde for 1 and 2.
On 2/2/2021. On 2/2/2021, at the request of learned counsel for the appellant, finally 2 weeks time was granted to take necessary steps, failing which the appeal shall be listed for necessary orders as against answered responding. In spite of granting sufficient time, the appellant has not taken the steps for the answered respond number 3. In view of the preemptory order, the appeal is dismissed against respond number 3 for not taking steps. Was passed over only on the ground that you are going to file an application. Same order. Request of limit council for the appellant, that will be listed there.
Serial number 15. K.V. Chandrasekhar Reddy. A movement for aviator respondent.
The subsequent shaft. Based on the readings, there is no primary issues. Now the extra issue, there is a different proof that the situation is very clear, the endorsement on the last page of the agreement is the court signature as compared to the application of right, you want to whether is argument. Very few features as well an application for sending disputed case. The High Court has rejected the application and proceeded to decide the matter based on the arrangement. The High Court has taken the risk of taking it. None left to signature in the Shara is not that of the defendants. And a 20 of the statement, the defendant has seriously disputed the conclusion of Shara as per the signature as per the next. He said that the signature is the fourth signature. The burden of putting the signature is the fourth signature on the defendant. It is working to mention here that the defendant may not be referring to this signature. To his opinion, he has a fine application. And now we have also fine application. In this application. So there is no objection for referring to the signature and whatever. And that's application is as a PLC. Now the discussion is that PLC. So the only condition is that they refer this application. We get purpose for it. That's only reaching it. I rejected the application. The developer himself has taken this exam in the how I found that I have paid a sum of rupees almost 1,30,000. What will remain is 3,020.
When a defendant filed an application, why you oppose that application? Read para 20. At whose instance it was rejected?
For the reason that the client has already examined and tested therefore, they were can be appreciated to come to the conclusion about this. signature. That is the application that we have.
Filed an objection to the said application. Good evening. That's all. Correct. A defendant has filed an application to send the disputed signature to the handwriting expert, wherein you are objected for that application. At your instance, trial court has dismissed the application. No, how can you file an application? That's all. Please give the reason, consider it. On what point? Well, on what point you are relying those judgments? ಅಲ್ಲ ಸರ್ ಅದ್ರಲ್ಲಿ ಏನ್ ಪ್ರಿನ್ಸಿಪಲ್ ಲೆಟ್ ಡೌನ್ ಮಾಡಿದಾರೆ ಅದು ಹೇಳ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
Although there is no legal power to compare the disputed writing even as a matter of course, I would caution SBI to base its finding because of the particular handwriting of prosecution case. It is the person accused of offense solely on comparison made by himself. Therefore, not avoidance of the defense. Therefore, on himself the task of comparing the
Whether in the given case which you are reading, whether an application was filed.
Yes. You are the other identical situation where we appeal that section 96 appeal of required especially they application was made for understanding comparing the dispute signature to that before the expert today's remark that expert shall not be able to self-responsibility on the handwriting disputed handwriting of prosecution unless a report is obtained, unless a report is obtained. This is essential because such an necessary requires other ruling laws of the law. The same
That's all. A1 of 2018 also dismissed. Appeal is dismissed. Reason for yes, you address the argument. Nobody prevented you from addressing. Sir, nobody prevented you from arguing the matter. Right now, you can argue the matter. Sir, I'll take up the matter on the final hearing. You argue the matter on May. No question of it. Is there any bar that the court should not take up the matters when a matter is listed for at the request of learned counsel for the petition appellant, let the appeal be listed tomorrow for final hearing. The first is serial number 1 for further hearing. Heard the learned counsel for the appellant, let the appeal be listed for further hearing. On the top of the list.
Serial number 20.
She has carried out amendment. We will allow the application. Correct towards dispose of the appeal on the appellate file I2 of 2019 seeking for setting aside abatement. File IA1 of 2019 seeking for condonation of delay of 1,835 days in filing LR application. File IA3 of 2019 seeking to bring the LRs of proposed respondent, sole respondent, learned counsel for proposed respondent submits no objection to allow the application, accepting the reasons assigned in the applications. I2 of 2019 is allowed, abatement is set aside. I1 of 2019 is allowed, delay of 1,835 days is condoned in filing LR application. I number 3 of 2019 is allowed. Appellant is permitted to bring the LRs of deceased respondent. Appellant to carry out amendment and to furnish amended constitution. Right now, carry out amendment. Next week.
Say number 28 and for the respondent.
Settlement ಆಗಿದೆ ಅಲ್ಲ ಅದೇ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದೆ ಯಾವಾಗ May 2020 we are in 2022 the request of the council for that. ಆರು ತಿಂಗಳು ಆಗ್ತದೆ
Serial number 29, GPN 1 moment.
This matter, my lord, I appear for respondent 1 and 2.
Yes, sir.
This matter, I'm sorry, I was in the other court when it was taken up in the morning.
It's okay, sir. It's okay. You argued the matter. That is sufficient.
Yes. Now, I learned that the appellant has not yet argued fully, and your lordship wanted some clarification regarding the property being the property of partnership. My colleague informed me that matter. Now, it requires some time to convince your lordship regarding this property being treated, because the conduct and the actions taken by all of them, treating it as a partnership firm, and for the business of the partnership, I can show to your lordship, even with the admission of PW1, saying that this property was the property where they were carrying on business, and in the balance sheet also of the firm, this is shown as property of the firm. Apart from that, they entered into
property was transferred in the name of firm, you tell me.
There is, that's what I want to submit, my lord. A property of a partner to the firm, there is no requirement of a registered sale deed or transfer deed. That is a principle of partnership.
Earlier, property was standing in the name of Sarojini.
Yes, after her death, these partners became the owners as legal heirs.
So where is the partnership deed? Show me the recital in the partnership deed.
No, in the partnership deed, it was not there. The property was
then,
of the.
How can you consider it as a partnership property?
Please. Partnership, when it was started long back, it was not the property of the partnership. It became the partnership property in 86. After the death of the lady, 82, then there was a settlement that exhibit D3 and D6, your lordship may kindly see, produced, which is signed by all of them. And D6, D6 only, it was shown as partnership property. And it was not from the date of the partnership deed, it was a property of the partnership. And partnership property, it became partnership property after the death of her, and by the inclusion of this by all the legal heirs. That is what is the exhibit. It is admitted by
show me the
PW1.
document to show that it is. Show me some document.
Yes, that's what I'm saying. A document, please see exhibit D6 nodi. D6. Your lordship got a paper book hakidare. Your lordship got page 167. Adal nodi fixed assets, goodwill, building. Your lordship got it. Goodwill and building anta bantalla. Your lordship got it. ಮೇಲೆ 31,386 ಅಂತ ಹೇಳಿದೆ ಆದ ಮೇಲೆ
ಬಿಲ್ಡಿಂಗ್ ನಂಬರ್ ಯಾವುದು?
ಅದೇ ಅಲ್ಲಿ ನೋಡಿ ಎನ್ಆರ್ ರೋಡ್ ಬ್ಯಾಂಗ್ಳೂರ್. ಒಂದು ನಿಮಿಷ there is no other property, there is no dispute about that, there is no ambiguity, there is clarity.
2 and 3 are also properties
of the firm. NR road is given to defendant in the dissolution. HR Street, Mysore is the property which item number 1. There is no other property mentioned there. Now, your lordship may kindly see, all the details are found in the earlier document also, and Kata was made. Everything I will point out to your lordship. And D3L node. D3L, there is reference regarding all these properties. 148 page ali this one. Your lordship got it? This is a document where statement of and division of the entire thing was made after the death of Sarojini Kanolkar by all the legal heirs, including the daughter. This is dated 16/6/83. Your lordship got it?
Yes.
Idರಲ್ಲಿ ನೋಡಿ next page ಅಲ್ಲಿ ನೋಡಿ ಎಲ್ಲ ಬಂದಿದೆ, including this particular property, page 2 ಅಲ್ಲಿ ನೋಡಿ. The immovable property bearing number 1670/1, Annapurna, Hanumantarao Street, HR Street hತ್ರ Hanumantarao Street, Mysore, having the value of so and so. ಅದನ್ನು ಈ 4 ಜನರಿಗೆ ಸನ್ಸಿಗೆ ಬರುತ್ತೆ, and daughter gives up. Next property ನೋಡಿ ಅದರಲ್ಲೂ ಇದೆ, other property building also, ಅದರಲ್ಲಿ ಎಲ್ಲ details ಇದೆ, and all these things are settled by between themselves, and accounts are taken, and the amount of value is also fixed. Thereafter, my lord, they included these property, all the 4 partners included this property into the firm. Then the firm became the owner, and or these partners held it as a property, and it is admitted by PW1 that this property is the place where they have been carrying on the business, and the even that I'll show to your lordship. PW1 ಸ್ವಲ್ಪ ಓದಕ್ಕೆ time ಕೊಟ್ಟು ನಾನು ಓದಿ ಹೇಳ್ತೀನಿ, because the time is short for your lordship. If you permit, I'll read PW1. ಇದನ್ನೆಲ್ಲ ಒಪ್ಪಿದ್ದಾರೆ. And the mode of acquisition of the property or submission of the property to the partnership is slightly different from general registered partition, registered deed of transfer. Because your lordship fully aware of this fact that partnership has no legal entity as such. It is the partners in a group. It is called compendium as the name. So these partners remained owners of the property till the dissolution. At the time of dissolution, all the four signed, and this is admitted by PW1. Even in the plaint, it is admitted. Plaint ಹೇಳ್ತಾರೆ, this has been done, and partners have entered into a dissolution deed. It is admitted, and in the dissolution, these properties have been given. May I submit, my lord?
Yes.
Properties ಈ ಡಿಸಲ್ಯೂಷನ್ ಅಲ್ಲಿ your lordship ಕಳಿಸಿ P10 ಅಲ್ಲಿ ತಾವು ನೋಡಿ P10 it's signed by all of them, admitted document, they don't dispute. And P10 ಅಲ್ಲಿ ಅವರೇ ಹಾಕಿದ ಡಾಕ್ಯುಮೆಂಟ್ ಅದ್ರಲ್ಲಿ ನೋಡಿ, item number 1 is given to my client, item number 2 is given to the another person, and item 3 is given to jointly to the other two persons with the 50% because its value was more. And the second defendant, your lordship can see, in that he sold the property based on this dissolution registered deed that is not challenged. And the other two persons, one is released 50% in favor of the other, and they became the absolute owner of that property. I became the owner of this property. This is a dissolution deed, and these documents is not challenged. This registered document not challenged. The purchaser is not made a party, and they are stopped from doing it. It is acted upon. It is not a simple signed document. They have acted upon, and even in the cross examination, PW1 accepts it. Plaintiff ಅಲ್ಲಿ para 2 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ there is a dissolution deed, and para 6 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ there is a dissolution deed. What they say is that has to be partitioned again. How it could be? Once they have decided that it to be treated as a partnership property and dissolution has taken place and admittedly documentation has been done after the dissolution, and that document is admitted, not disputed, and acted upon. That is one thing. I will read to your lordship PW1's evidence. P10 ನಲ್ಲಿ it is treated as partnership ಅಂತ ಬರೆದಿದ್ದಾರೆ. Now how all have signed. How can they now say that it is not a partnership property? So the method of getting the property into partnership is entirely different, not a registered deed. And they have adopted through the chartered accountant, they have made this, and even the balance sheet, it has been treated as property. Then they have divided, and they have been examined and not disputed this document. ಇನ್ನೊಂದು ಏನಂತಲ್ಲ, ಸೇಲ್ ಆಗಿದೆ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. After the sale, the purchaser is not made a party. They say that Mysore ಇನ್ನೊಂದು site ಇದೆ, that is also not included in the property. Sorry, I made some more submission before your lordship notes down. I am sorry. Please excuse me. I will make my submission after your lordship notes down. In a hurry, I just continued in a hurry. I am sorry.
No, continue.
May I request your lordship to take P10, my lord?
P10. Page number?
P10, page number 86. Paper book 86 ಇದೆ ನೋಡಿ. This is a document signed by all of them and not disputed. Please permit me to read it, because this is the basic document on which all of them claim. That's why, if your lordship permits, even though time it takes a few minutes, I may be permitted to read.
Yes, you can read.
First page ನಾನು ಬಿಟ್ಬಿಡೋಣ, ಯಾಕಂದ್ರೆ all of them are parties ಹೆಸರುಗಳು ಹಾಕಿದ್ದಾರೆ. Whereas the first, second, and third, and fourth, fifth, and sixth parties have been carrying on the business under a deed of partnership dated 5th August 68. Under the firm name of S.S.P.S. Kanolkar, duly admitting to the benefits of partnership, master, etc., the juniors, our minors are admitted, whereas all the parties have decided to dissolve the firm from 1st January 87 and distribute assets of liabilities mutually agreed upon. Now this deed of dissolution witnesses the aforesaid partnership is hereby dissolved with effect from 1/1/87. The capital current accounts balance different etc. Amount. May I read that, my lord? That
Yes.
The capital and current account balance of the different parties shall be settled in the manner following by their taking over the respective amounts in liabilities indicated against each of them. Prabhakar Kanolkar, second party, capital as balance sheet as on 31/12/86, 20,000, current account balance so and so. This is over the amounts. Less assets transferred at book value, balance sheet as on 31/12, 50% interest in the shop premises, bearing number 17. Please see this, my lord. This is the item number Narasimharaju 2. Otherly 50% avariಗೆ ಇನ್ನೊಬ್ಬರಿಗೆ 50%. Item number 3 ಅದು. Item number 3, my lord.
Yes.
Item number 3 is Usmania building, NR Road. This is the Narasimharaju Road building, ground floor, etc. First floor, bearing number 33, forming part of commercial building complex Usmania building, bounded on the north by etc. The particulars. Let us not waste time over that. And measuring etc. Valued at so and so. Balance amount so and so. Then balance amount due to be paid by the third party so and so. Then Madhukar. Madhukar is through whom they claim. Current account debit balance so and so. Less capital as per balance sheet 20,000. Capital Manohar Ganesh etc. The Makladu. And credit balance to current master Ganesh Khanolkar as per balance sheet. The assets transferred. Next, balance sheet number so and so, 50% interest in the premises number 17 Narasimharaju Road. So this is the third item. So 50% ಇವರಿಗೆ 50% ಅವರಿಗೆ. That's what I said in that building. Your lordship wanted to know where you get it. This is the 50% and 50%. Then, my lord, the details are there. I will skip over with your lordship's permission. The entire property, which the same details are there. Other than it. Next, number C, nodi, page 5 only. Manohar V. Kanolkar, fifth party.
Yes.
Capital balance, etc. amount ಬಗ್ಗೆ ಹೇಳಿದ್ರು. ಅದರಲ್ಲಿ ನೋಡಿ, less book value as balance sheet in the 31/12/86 of the site bearing number corporation number 6, New Akitimanahಳ್ಳಿ layout, Shanti Nagar, Bangalore. This is the property, my lord, allotted to him. He sold it. Now the plaintiff files a suit after selling this. Please see, Shanti Nagar, Bangalore, measuring 79/70, valuable property. Bounded on the east by so and so, measuring 79/78. Such a big property is given to them. That's plaintiff number 1. They conveniently sell it subsequently to Manohar, and now they file the suit. And this property, you lost pause for a while. This property is now excluded in the suit. Sorry, in the sense, not sold, not excluded, not impleaded that person who purchased. Manohar ke sale madide to bandide adu. There is an exhibit.
Yes.
So the plaintiff number 2 in favor of D1. ನೀವು ಒಂದು ಮಾಡಿ what I give is the details ಎಲ್ಲ ಓದ್ಕೊಂಡ್ರೆ ಟೈಮ್ ಆಗುತ್ತೆ. This property is allotted to them. Then, my lord, next page. VS Kanolkar ಅವರಿಗೆ ನೋಡಿ, ಅವರಿಗೆಲ್ಲ ಅಮೌಂಟ್ಗಳು ಅದನ್ನು ಬಂದಿದೆ. Then business ಅದರಲ್ಲಿ F ಅಲ್ಲಿ ನೋಡಿ, page 91 book ಅಲ್ಲಿ F Anand V Kanolkar. Your lordship got it? 91. Page 91 ಅಲ್ಲಿ. VS Kanolkar ಗೆ ಕ್ಯಾಪಿಟಲ್ ಅಮೌಂಟ್ ಕೊಟ್ಟರು. ಫಾದರು Anand V Kanolkar, current account. Then current account debit balance etc. as on 31/12/86. Next, add business premises. Your lordship can see the last Annapurna. Your lordship wanted to know where are the details. HR sheet andre idene.
Yes.
Annapurna situated in Hanumantarao Street. That is the HR Street, Mysore. Bounded on the east, bounded etc. East by Conservancy, west by road etc. and north by Prabha Talkies, and on the south by chemical electroplating factory works etc. Built up area, everything. Then nodi. And valued as per balance sheet as on 31/12/86. Adanu valuation madidare. So this property is valued and allotted. Then business. Adರಲ್ಲಿ third parties ಅದರ details ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. The balance sheet I was referring to is that D6 period. In that this property HR ಕೇಳಿದ್ರಲ್ಲ, what is this property ಅಂತ HR ಅಂದ್ರೆ ಅದನ್ನೇ ಹನುಮಂತರಾವ್ ಸ್ಟ್ರೀಟ್ ಅನ್ನು ಹಾಕಿದ್ದಾರೆ. And this finds a place in this page 91. So if this is not treated as partnership property, where was the question of assessing these three properties and dividing among the four partners? And for this, father is as a party, not only my client. ಅಲ್ಲಿ ನೋಡಿ ಈ VS ಕಾನ್ವಲ್ಕರ್ ಅಂತ ಹೇಳುವುದು ಫಸ್ಟ್ ಪಾರ್ಟಿ ಅವರೇನೆ, ಫಾದರ್. ಅದು ಅವರಿಗೆ ಪ್ರಾಪರ್ಟಿ ಕೊಡ್ಲಿಲ್ಲ, ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ 1,35 lakhs. Your Lordship, see back page number 91, ಆ ಪ್ರಾಪರ್ಟಿ ಇಂದ ಮೇಲ್ಗಡೆ ಬರೆದಿದ್ದಾರೆ ನೋಡಿ, page 91 ಅಲ್ಲಿ, page 91 ನಲ್ಲೇನೆ, ಐ ಆಮ್ ಸಾರಿ ಐ ಸ್ಕಿಪ್ಡ್ ಇಟ್. ಈ ಅಂತ ನೋಡಿ VS ಕಾನ್ವಲ್ಕರ್ ಅವರಪ್ಪ ಇವರೆಲ್ಲರ, all of them are parties. Then my lord, the ಪ್ರಾಪರ್ಟೀಸ್ ಇಷ್ಟೇ ಬರೋದು, ಬಾಕಿದೆಲ್ಲ ಹಾಗೆ ಹೋಗ್ತದೆ. ಈ ಮೂಲ ಪ್ರಾಪರ್ಟೀಸ್ ಇಷ್ಟೇ ಬರ್ತದೆ. ದೆನ್ ಇಲ್ಲಿ 93 ಅಲ್ಲಿ ನೋಡಿ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಪೇಜ್ 93 ಅಲ್ಲಿ ಪಾರಾ 3 ಅಂತೇಳಿ, ಆಲ್ ದಿ ಪಾರ್ಟೀಸ್ ಹಿಯರ್ ಬೈ ಅಕ್ಸೆಪ್ಟ್ ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ದ ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟೀಸ್. ಯು ಲಾರ್ಡ್ಶಿಪ್ ಗಾಟ್ ಇಟ್?
Yes.
Page 93 ಅಲ್ಲಿ ಪಾರಾ 3. All the parties hereby accept the transfer of assets and liabilities as above based on the balance sheet of the firm as on 31/12/86, and the third party is taking over the major assets and liabilities, confirms his liability to the other parties as indicated above, and first, second, fourth, fifth and sixth parties hereby release, assign, disclaim the etc. all their etc. in the partnership. This was the account stated. Then my lord, who had undertaken not only to discharge the liabilities of the first, second, fourth, fifth and sixth parties as worked out above, etc. In witness whereof on this day they have signed the document. In this, please see VS Kanolkar, first party father, then Prabhakar, then Anand, Madhukar and Manohar, also Josna. All these are parties, and it is witnessed by one of them is I am told that is a chartered accountant of their firm, and he has also signed it. And then my lord, now your lordship can see, this is a document under which they calculated everything. Then they entered into the P10. P10 ಅಲ್ಲಿ dissolution ಆಯ್ತು. Dissolution ಆದ್ಮೇಲೆ acted upon, that is one thing. Would your lordship see exhibit P2, a release deed of that 50% of the share by one to the other, P2. Release deed dated 6/6/91. 81 ಇರಬೇಕು ಅದು. 91. Plaintiff number 2 in favor of defendant number 1. Page 51, my lord. Your lordship gets in your paper book 51.
Yes.
In that, my lord, the plaintiff number 2, that's a Madhukar, so and so, release deed is made and executed on this 6th day of June 91 by Madhukar, aged about 48 years, etc. Address is given here now by the first party, which expression shall mean and include all these as legal successors, etc. In favor of Prabhakar V. Kanolkar, that is between the brothers, first defendant. That is another thing. He released it ಅಲ್ಲಿ, there is a reference to this dissolution of the partnership and this property being allotted to them, and the Usmania building ನೋಡಿ ಕೆಳಗಡೆ ಬರುತ್ತೆ, whereas the books ಇಲ್ಲಿ ನೋಡಿ page 53 ಅಲ್ಲಿ your lordship got it, whereas the books of the firm, the building more fully described in the schedule here under ground floor, etc. of Usmania building, Narasimharaja Road, Bangalore, book value so and so, purchase, etc. That is how they got it earlier one. Then, Basangudi, Bangalore. Then, and whereas the partners, second page, third line, whereas the partners of the said firm decided to dissolution of the firm, and the firm was dissolved by the deed of dissolution dated 15/1/87, and while the assets and liabilities of the business were taken over by partner Sri Anand, so and so, the Bangalore property number so and so, Usmania building was taken over by the first and second parties, duly debiting, etc. as on 31/12/86, the amount. Each whereby the first and second parties have taken possession of the so and so building number 17, Usmania building, Narasimharaja Road, Bangalore, absolutely for their benefits, and have joined. I'm sorry. Joint owners of the property from the said date have been in possession thereof, using the same for their business, and whereas the said deed of dissolution clearly indicates the assets and liabilities taken over by each of the partners, and the said deed stands signed by all of them. The said deed of dissolution evidences the joint partnership of the scheduled property. This is the acronym here, my lord. Page 54.
Yes.
He is a defendant. So the plaintiff number 2 is the part here. The said deed of dissolution evidence the joint partnership. Said deed of dissolution evidence of the joint partnership of the scheduled property by the first and second defendant parties. Whereas the first party has since established a business in Mysore and is willing to release the 50% interest of the scheduled property in favor of the second party. Now this deed witnessed. Operative portion. So this is 50% ಅವರು ಇವರೇ ಕೊಟ್ಬಿಟ್ರು. Then Narasimharaja Road property, he became the absolute owner.
Yes.
ಇನ್ನೊಂದು ನೋಡಿ ಅದರಲ್ಲಿ page 55 ಹೇಳ್ತಾರೆ, the first party with a view to secure for the second party absolute right over the scheduled property without any manner of doubt request the erstwhile partners of V.S. Kanolkar, etc. ಎಲ್ಲ ಹೇಳ್ತಾರೆ. So the first party hereby absolutely discharge its own relinquishes in favor of the second party. That's the operative portions ಎಲ್ಲ ಅದನ್ನೆಲ್ಲ ತುಂಬಾ ಇದೆ ಅದು. And ultimately what they say is their 50% is given to the other man. So the other second party becomes the absolute owner. And this shows that they rely upon the dissolution, they act upon the dissolution. Now plaintiff number 2 says that the property is not property is to be divided into 4 pieces.
Yes.
Next P3 ನೋಡಿ ಸ್ವಾಮಿ.
Yes.
Page 63 ಇದು ಬರ್ತದೆ, ಬಾಕಿ ಎಲ್ಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಡೀಟೇಲ್ಸ್. page 63 ನೋಡಿ. The sale deed ನೋಡಿ. This document ಆಯ್ತಲ್ಲ, sale deed. This deed of sale made and executed on the 8th day of February so and so ಅಂದ್ರೆ 88 ಗೆ by Manohar Vishram Kanolkar. That's the first plaintiff residing page 63 residing at Annapurna, etc. Hereinafter called the seller, which expression wherein requires shall mean and include his heirs, legal, etc. in favor of Sri R. Manohar, son of Ramchandra Asudamal. The R Manohar but R ಇಲ್ಲ ಅವರು ಬರೀ ಒಂದು R ಇದ್ದಂಗೆ ಕಂಡಿಟ್ಕೊಂಡೆ. The original R ಮಾತ್ರ ಇದೆ. Anyway, ಮನೋಹರ್ಗೆ ಸೇಲ್ ಮಾಡಿದ್ರು ಅವರು. 21 years residing at Avenue Road, Bangalore. Hereinafter called the purchaser. Then either ನೋಡಿ next, whereas the seller above named is the full and absolute owner of the vacant site bearing number 6 situated in survey number 27 Akkitimmanahalli, now called the Shantinagar, Bangalore, situated in the corporation division number 64, more fully described in the schedule here under and hereinafter called the scheduled property. For sake of convenience, wherever the scheduled property, etc., belonged to Anand V. Kanolkar, the brother of the seller above named who purchased the same, etc. From Sridhar and others. Then next Rodi, out of the self exertion, then next Rodi, that property was converted into a partnership. That is a kata next. Whereas the Anand by deed of gift, so and so gift, so and so, share ಅವರೊಳಗನೆ ಆಗಿರೋದು ಅದು ಬಿಟ್ಬಿಡಿ. ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಪಾರ 65 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪಾರದಲ್ಲಿ, whereas subsequent to the aforesaid gift, the scheduled property was brought into the books of account in the firm. Your lordship got it? Ali, it was brought into the books of account of Messrs. V.S. Kanolkar. Your lordship wanted to know how it came to the firm. Became the owner of the and the said firm became the owner of the scheduled property, and etc. As the absolute owner thereof, paying that, etc. Then, on the request made by the partners, the said Messrs. Kanolkar Propriety made the kata and etc. Then, next, whereas the seller, along with the father and brother, referred to above, were throughout partners of the said firm, Messrs. V.S. Kanolkar, ever since it started it firm partnership 60. The only change in the constitution of the firm has been admission of Srimati Sita Krishna Swami, sister of the seller, as a partner under a deed of partnership dated 71, and she retired from the firm on 31/3/75 as evidenced in the deed of partnership dated 75, when the original 5 partners continued in the business of firm Messrs. V.S. Kanolkar. The said firm was again reconstituted in 83, and original 5 partners admitted Jyotsna P. Kanolkar, daughter of the seller, brother of Prabhakar so and so, as the partner. This is how the partnership went on. Then, my lord, next page 67 notice. That is how the partnership changes. That now 67 nodi. Whereas the aforesaid partners of V.S. Kanolkar dissolved the said firm and the assets thereof, which includes the scheduled property, Nodi. They say that which includes the scheduled property, page 67 only, were distributed amongst the partners of their shares, and the scheduled property was allotted to the share Manohar, etc. Manohar Kanolkar, seller above named, under the said deed of dissolution dated 87, and from the date of dissolution of the seller became full and absolute owner of the scheduled property, and he has been enjoying the same exclusively and paying necessary taxes, etc. by virtue of, your lordship say kindly is a word used, by virtue of the dissolution of the said firm, etc. Adanna refer ಮಾಡಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Whereas sellers above named is in the need of ready liquid cash, etc. Now this indicates that he has sold the property to the Manohar, another person, Ramchandra's son, another third party, nothing to with us. This property, what is sold is that property is based on the dissolution only. Otherwise, they could not have sold it. If it were
page number 111.
111. Yes, my lord.
Read the last paragraph of cross-examination.
At the time of execution of the dissolution deed, it starts like that. At the time of execution of the dissolution deed, the value of the goodwill of 20,000, there is no writing with regard to the distribution of the goodwill among the other partners. It is false to suggest that at the time of dissolution of the partnership firm, there was no idea of distribution of the goodwill among the partners. D6 is the document to show that schedule item number 1 is the asset of the partnership firm. Asset of the partnership firm. Except D6, there is no document to show that transfer of the scheduled property in favor of the partnership firm, either by Sarojini Kanolkar or after the death of legal representative. There is no other document. There is no registered document. It is true that except the dissolution deed, there is no other document to show that other shares in the partnership have executed transfer deed. No transfer deed in favor of the first party in suit item. I have no document to show that suit item number 3 is transferred by other sharers by partnership in favor of so and so. I have no document to show that Kanolkar distributed properties partnership among the sharers. These are all, your lordship kindly see. Now I read to your lordship the document where they are all parties. Oral evidence, whatever they say against or for, will not take us anywhere. and they have settled it. All of them parties to that. Dissolution deed signed, accepted. Now, even if he says that there is no other document, it is certainly against the matter on record. It cannot be accepted. Most probably, your lordship wanted this explanation based on this in the morning.
Yes.
That is redundant. This statement is redundant in view of the admitted documents which are not challenged. Then, my lord, at the same time, I request your lordship to permit me to read PW1. ಇಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇದನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ, ಪ್ಲೀಸ್ ಸಿ PW1 ಎವಿಡೆನ್ಸ್. PW1 25 ಅಲ್ಲಿ ಇದೆ ಪೇಜ್. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ, 25 ಸಿಕ್ತಲ್ಲ, ಪೇಜ್ 25 PW1. ಇದರಲ್ಲಿ ನೋಡಿ, ನನ್ನ ಮಾವ ಪ್ರಸಿದ್ಧ ವ್ಯಾಪಾರಿ ಆಗಿದ್ದರು ಎಟ್ಸೆಟ್ರಾ, ಸಾಕಷ್ಟು ದರ ಆಸ್ತಿಗಳು ಹೊಂದಿದ್ದರು. ನನ್ನ ಅತ್ತೆ ಹೆಸರು ಸರೋಜಿನಿ, ಹನುಮಂತರಾವ್ ರಸ್ತೆಯಲ್ಲಿ ಅನ್ನಪೂರ್ಣ ಎಂಬ ಹೆಸರಿನ ಕಟ್ಟಡ ಹೊಂದಿದ್ದರು. ಸದರಿ ಕಟ್ಟಡದಲ್ಲಿ ಕಾನೋಲ್ಕರ್ ಎಂಬ ಪಾಲುಗಾರಿಕೆ ಸಂಸ್ಥೆ ಇತ್ತು. ಇದು ಚೀಫ್ ಅಲ್ಲಿ. ಐ ರಿಕ್ವೆಸ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು mark this sentence in chief, not the cross. Cross ke matte bartini. So this firm was doing the business in this property. Then 15/87 ರಂದು ಸದರಿ your lordship permit me this ಆ ಸಂಸ್ಥೆಯಲ್ಲಿ ನನ್ನ ಮಾವ ಮತ್ತು ಆತನ ಪಾಲುದಾರರಾಗಿದ್ದರು. ಅವರ ಹೆಸರು ಎಟ್ಸೆಟ್ರಾ. 15/87 ರಂದು ಸದರಿ ಪಾಲುಗಾರಿಕೆ ಸಂಸ್ಥೆ ವಿಸರ್ಜಿತಗೊಂಡಿತು. Could your lordship see? This is a admission in the chief, not cross. Then ಈ ವಿಸರ್ಜನೆ ಪಾಲುಗಾರಿಕೆ ಸಂಸ್ಥೆ ಮತ್ತು ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಆಸ್ತಿಗಳ ಬಗ್ಗೆ ಮಾತ್ರ ಇತ್ತು. ಆ ವಿಸರ್ಜನೆ ಕುಟುಂಬದ ಆಸ್ತಿಗಳ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿರಲಿಲ್ಲ. ಸದರಿ ಕಟ್ಟಡ ನನ್ನ ಗಂಡನ ಅವಿಭಕ್ತ ಕುಟುಂಬದ ಆಸ್ತಿಯಾಗಿತ್ತು, ಎಟ್ಸೆಟ್ರಾ. Then, my lord, now I take your lordship to cross. Then she says
number 32 last line from the bottom.
32, my lord.
Yes.
ಹೌದು, 32 ಅಲ್ಲಿ ಇಲ್ಲಿ 30 ಅಲ್ಲಿ ಒಂದಿದೆ ನೋಡಿ. ಮೇ ಐ ರಿಕ್ವೆಸ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಪರ್ಮಿಟ್ ಮಿ ಟು ಪೇಜ್ 30, ಸ್ವಲ್ಪ ಹಿಂದಕ್ಕೆ, ಒಂದು ಪೇಜ್ ಹಿಂದಕ್ಕೆ. ಶಾಂತಿನಗರ ಪ್ರಾಪರ್ಟಿ ಹೇಳ್ತಾರೆ ನೋಡಿ. ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ, ಫಾದರ್ ಇನ್ ಲಾ ಹ್ಯಾಡ್ ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಸಿಚುಯೇಟೆಡ್ in ಶಾಂತಿನಗರ್ ಎಟ್ಸೆಟ್ರಾ. This is one allotted to their share. Then residential house in Shantinagar, Bangalore was bequeathed, etc. It is true that site bearing number so and so Madhuvana layout. This is not included in the suit. It is true that the site property situated in Madhuvana layout, Sri Rampura, Mysore, is also belongs to my father-in-law. Witness volunteered that we came to know about this property after 2-3 days of his death. It is true that the said property is not bequeathed to anybody. We did not include this property in the suit as we were not aware of the existence. It is true that as on the date of the filing of the suit, we were aware of the allotment of the site in the name of my father-in-law. It is false to suggest that we have not deliberately included the said property in the suit. Witness volunteers, we were not having the documents. Those documents are with the Madhuvana Cooperative Society. Now we have only Xerox copies pertaining to the property. House Cooperative Society had given Xerox copies of the said property before filing the suit. This is page 31 ಅಲ್ಲಿ para first ಅಲ್ಲಿ last sentence ನೋಡಿ. Society had given Xerox copies of the said property before filing the suit. So that means ಅಲ್ಲ, ಇಲ್ಲೊಂದು ನಾನು ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ ಈ ಸೆಂಟೆನ್ಸ್ ಸ್ವಲ್ಪ ಇಂಪಾರ್ಟೆಂಟ್. ಯಾಕಂದ್ರೆ they were having the details of the property as per the Xerox copies of the document given by the society before filing the suit. ಆಮೇಲೆ my father-in-law died in 1892. It is true that item number 1 of the suit property was purchased by mother-in-law. It is true that enjoyed the property till her death, etc. It is true that died on so and so. It is false. Now your lordship pointed out last line. As on the date of death of Sarojini Kanolkar, my father-in-law Kanolkar, Madhukar, Kanolkar and Manohar were the partners of Mrs. V.S. Kanolkar. I admit that was not the property of partnership at that time. Then it became. I read to your lordship the entire statement, what was added and all that. It's all subsequent. This business of the partnership was being run by item number 1 of the schedule. Idu nodi, business of partnership was being run in item number 1. 31 alli nodi. After the death of Sarojini Kalolkar also, witness volunteer that this firm business is being run in item number 1 of scheduled property since beginning. I do not know what capacity firm's business was being carried on after the death of Sarojini Kanolkar. Witness volunteer that during the lifetime of the Sarojini Kanolkar, partnership firm was a tenant under her. There is no document indicating the payment of rent, but the estate duty purpose statement was prepared. It is false to suggest that that is showing her as the owner. I don't dispute that. After the death, these all the illegal heirs entered into this.
According to you,
yes.
According to you, and as per Exhibit P10, item number 1 to 3 has been already divided in between plaintiff and defendant.
Yes, yes.
And plaintiffs have acted upon Exhibit P10
yes,
and
correct.
executed a register sale deed in favor of third person.
That's why regarding one item. Third party. That is Shantinagar property sale madiddu. And 50% share kottavaru, or one of them executed a registered release deed in favor of the other. He became the owner of fully. And I am the still owner of that. So sale is only Shantinagar property. So by registered deed acted upon. So
yes, yes.
ಇನ್ನೊಂದು ಪೇಜ್ ನಮಗೆ if your lordship permits.
reply the ledakatre.
No, I am sorry. I was asked to answer this question earlier. And now that your lordship knows that he has to make out a case for on the merits, I will answer after my learned friend argues. I will not avoid the question put by court. That is why I had to answer this. I'm sorry for taking a lordship a lot of time. Let him argue on what basis he can claim as in the suit.
That is admitted in class examination. Only in item number 1 property which belongs to Sarojini. This was not a part of the any point of time.
But you executed a register sale deed wherein there is a reference about the deed of dissolution. What are the contents of Exhibit P10? Item number 1. Have you challenged that the Exhibit P10? On the basis of Exhibit P10, you have executed a register sale deed, and there is a clause in the register sale deed. There is a recital in the sale deed that on the basis of a deed of dissolution, the vendor has acquired the property. And also plaintiff number 2 has executed a release deed. Then how do you overcome these documents?
Ultimately, point that we come down to criteria. How did the property come into the partnership firm? Can you see copy of the partnership? But can you see what happens is, but no doubt the business is running under the building. Also, because the building belongs to the Sarojini, who is the mother. The looking at the partnership practice, subject to contract with the party, and the property of the firm includes all property rights in property originally brought into stock of the firm or acquired or purchased otherwise by or the firm or for the purpose of the course of business of the goodwill of business. However, here we are only concerned with the first portion, which says includes property and rights and interests of originally brought into stock of the firm. Let them point out on what basis this property is brought into stock of the firm. But including it in dissolution does not make it stock of the firm. So how does a dissolution deed, which divides the parties into the partnership, how does it become the basis to say
You are a signatory to exhibit P10.
yes, I'm not disputed that fact. But what I'm trying to point out to the world is that does not take away the fact that the property was not from the firm. My contention of the law is only this. But this property,
Why that property was included in the deed of dissolution?
the deed of dissolution was a basic tax purpose. But there is no valuation that is provided for them. Kindly move only to this point out. Kindly see what the document. But the two things become very relevant. The sale that I execute are the sort of two properties which relate to
From 2 and
second two activities. That property is not in dispute. But I point out to the processor. Therefore, the distinction has to be drawn as to how a property which belongs to my mother is thought to be included in the dissolution deed. But can such inclusion, but tomorrow what I will say, Vidhan Sabha is my property included in the dissolution deed. But can it be said, because you included in the dissolution deed, Vidhan Sabha belongs to me? I can't say so. Unless you show that this property was brought within the common joint stock of the firm. So what document do they have to show that this property belongs to the firm? But it is a matter relating to the rights to property. And what's the relevant word that it has to be only by a registered document unless you point out it is a joint stock of the firm. But they cannot not simply include it in the dissolution deed and then contain none of the properties are divided. But that is the prerequisite for purpose section 20. Right? That we talk about a judgment not being on the point. Because we did this, there it is just turn back 35.
yes.
ಐ ಆಮ್ ಸಾರಿ, ಒಂದು ಸ್ವಲ್ಪ ನನಗೆ ಅವ್ರ ರೆಫರೆನ್ಸ್ ಹೇಳ್ತಿದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ. ಐ ವಿಲ್ ಆಲ್ಸೋ ಲುಕ್ ಇನ್ ಟು ಇಟ್.
2003 volume 6 SCC 423.
2003-6.
SCC 423.
423. ಪಾರ್ಟೀಸ್ ನೇಮ್ಸ್ ಲೆಟ್ ಹಿಮ್ ಒಂದು ಹೇಳ್ಬಿಡಿ ಸರ್. ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರೆ ಚೆನ್ನಾಗಿರ್ತಿತ್ತು. ನಾರಾಯಣ ಭಟ್ರು, ಸಾರಿ, ಐ ಆಮ್ ಸಾರಿ, ಐ ಕುಡ್ ನಾಟ್ ಗೆಟ್ ಇಟ್.
2003 volume 6 SCC 423. Then I will second across your colleague. Section 14 of the partition, the absence of an agreement to the contrary, property exclusively belonging to a person or entering into a partnership with others does not become the property of the partnership merely because it is used to business of the partnership. That property will become the property of the partnership only if there is an agreement expressed or implied the property was under the agreement of the partnership to be treated as the property of the partnership.
Good morning. That is a question which I asked.
Exactly. But I asked for the right question. So that is the only word way on which they can point out how the property became the property of the firm. So kindly for me to take cross to the cross examination, but who points out that the business was carried on in this very premises even before Sarojini died. But sir, Sarojini got she died in 1982. This business not this property was purchased by her in 1953. Exhibit P1 page 44. It's the same thing. Admittedly, she was never a party to the partnership firm.
Page number 110, para number 2.
Please.
Was on a rental basis.
Yes. She admits that is a different topic.
Page number 110.
Yes. Page 110. That property was given by Sarojini Karnataka on rental basis to the partnership firm. There is no document to show this deed agreement. But can also person was carried on page 109 bottom portion. Last two sentences. In the property belonged to Sarojini Karnataka, the husband had not taken any shape for himself. He has not executed any document raising his rights to the property. This is already put this signature on the date of this. Then what page 110 second paragraph.
Continue day after. Day after.
May I know the date, my lord? What my
Friday. Friday.
Friday. Apply, madam. Friday I will come.
ಇನ್ನೇನು ಮಾಡಿ ಕಳಿಸ್ಲಾ